Oh dear. Oh dear. We got some problems here. Give me 1 second. Hey. All right. Sorry guys, this is a little bit last minute because I had a doctor's appointment. I didn't know if I was going to be ready to do a live. So, good morning. Aren't you so happy that I brushed my hair for you? So, if you are new here, hello, welcome. My name is Lacey Jane, and this is Criminally Confident. I have been covering the Tyler Robinson hearings since they started, and I've been very interested in seeing how this is going to all play out, especially after this month's ruling by the judge that he is going to keep everything the same despite the defense's request to
That's how you can tell.
That's fair.
office removed from this case.
I hear you. Yeah. Okay. Well, we can do it. We can.
Good morning.
This is smaller, isn't it?
All right, Kristen. Hi, Mitchell. Don't forget to hit the thumbs up, please. And if you are one of the other people watching, please make sure to hit those buttons and post a comment. Another interesting fact, one of Tyler's attorneys is actually the co-counsel for the Kouri Richins case, which I have been covering every day. So makes sense why they weren't in court today, huh? Yep. No worries. Yeah, doctor, you knew about the doctor's appointment. Just gonna move some things around. She had to double check like before I have surgery, I have to have a ultrasound done of my artery in my stomach, like the carotid artery, but it's an abdominal one. What do I talk about on Discord? My Discord is pretty much to just like let people know that I'm going live, and we have a couple of other conversation topics, but yeah, it's just a good way for people from YouTube to connect with people, I guess privately. Thanks guys for being here. Please make sure to hit the subscribe button if you are new. I have a live stream that I do every day from Tuesdays through Fridays, beginning at like 4 o'clock usually. I've been playing around with the time a little bit, and I'm still gonna do it today, but this has been important to me, so I did want to make sure that I covered this. And I'm sure we're going to get a lot of people in here who are watching on replay. So, hey, replay crew, please make sure to show me some love by hitting all the things and dropping a comment. Welcome, everyone. I just got my glasses tightened and they feel like I feel like they're already super
Told you he's the most handsome. She didn't believe me.
flexed out again.
Oh, nice.
Oh, it happens. I'm kind of nervous about this. I'm not going to lie.
But she should be getting her.
I was shocked that the judge dismissed the motion this month in this case. I think that it absolutely provides Tyler Robinson with an appeals case if found guilty, which based on his representation, which is Nestor from Kouri Richins' trial, yeah, I don't think Rosef stands a chance. Did you hear that? This is the guy who allegedly unalived Charlie Kirk. It's quiet for me too, guys. Look at this. I'm hitting that like button. Hopefully you're doing the same for me. If you're watching on your phone, just double tap the screen.
Better not be here. How dare you?
How dare you? That's a good point, Kristen. I should probably write on here that this is who Tyler Robinson is. Hey, Stan, welcome. I'm glad that you got the notification to jump on in. Yes, Nestor's here. Yeah, you can tell if you watch the video all the way at the end from video. I sound so old. Corey's live last night, the court hearing. Trial, Lord help me, you can hear Nestor say, as late as possible would be great, Your Honor. I know, girl, I know. Just a reminder, if you are just jumping in here and you are new, hello, welcome. I do this every day, Tuesday through Fridays in the afternoons. Please make sure to subscribe and hit the like button. We have a great time around here, so I would love to have you guys part of the crew. Also, I think this is important to mention. I currently have 50-mile-per-hour winds outside. So hopefully my internet's okay. But okay. Yay, look who's here. That's great, Josh, because one of my other mods has another stream that they have to go to. So thank you for being here. I spoke to Maybe last night. I know a lot of people have been asking about her. She is just super busy with her family, caring for her husband. So I said that you guys have been asking about her. I'm going to do a poll and see what brought y'all here. What are you guys doing on this this Friday? Okay, Whoopsie Doo said, I'm new, so maybe a dumb question. Do you only cover this case or multiple? Thank you, Kristen. Yes, I do multiple cases, both new and old. Because we always like the OGs, right? This is an important case to me, though, so I will be covering it thoroughly. Once there is anything worth hearing, we'll hear it. They're just quiet right now. Court has not officially begun. Okay. I'm getting the poll together. Sorry, guys. No problem. I'll be off by 2 p.m. Eastern. I hope. So the hearing's supposed to start at 11:45, which is why I said 11:50 because I knew that they were going to be late. I am still planning on doing my regular live stream. So I hope this isn't like the one in January that lasted like 6 freaking hours. Here we go.
Please be seated.
Oh my gosh. Nikki.
Court is now in session. And video recording may begin. Calling case number 251-501-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
Chad Brumander, Ryan McBride, with Alex from the state.
Good morning to the prosecution.
Good morning, Your Honor. Richard Novak, Stacy Visser, Michael Bird, present in court with Mr. Robinson, and Ms. Nestor is appearing by WebEx.
Good morning to defense.
Ooh.
Good morning, Mr. Robinson.
My lights flickered.
Do we have any other parties present? Good morning to you as well.
Yeah, nobody knows who you are, ma'am.
All right. Before we begin, I want to address the first issue, which is the issue of the December 11th transcripts. I'd appreciate an update as to the status of any proposed redactions. We've talked about this before, but I want to address it and see when I might expect those. Okay, so council, sorry, let me begin. In an abundance of caution, we have turned off the microphones at the desk so nothing can be captured. You have to come to the lectern. So what you have to say is important, and I that to ensure to be cautious.
Thank you. Your Honor, I actually think the court reporter filed the transcript with the court last night, the redacted version, fully redacted. So I believe that's taken care of.
All right. Well, it's good to know.
Are you talking about
Mr.
Ricada?
Ballard. And you have to come forward. Sorry. We're going to get our steps in today.
I know I made that difficult.
Just going to agree that that's my understanding is that's been filed. We've agreed on the redactions, and so that should be taken care of. Thank you.
Thank you, Mr. Ballard. All right. I wish to address media coverage and related considerations as it relates to this hearing. The court wishes to remind all parties that the February 25th, 2026 standing decorum order is in effect and will be enforced to protect the constitutional rights of all parties while preserving the integrity, fairness, and orderly conduct of these proceedings. I would also ask counsel to be mindful that the microphones, and we've turned off the microphones at your counsel table, but just to be mindful that microphones, even from the lectern, can pick up conversations. Counsel may wish to consider using screen protectors on laptops, taking reasonable steps such as covering one's mouth when speaking to avoid the inadvertent capture of private communications, whether by camera, microphone, or by those present in the courtroom. Third, the court wishes to address the camera operator and still photographer. And so I respectfully ask Ms. Seitz and Mr. Dolan if you would step forward to the lectern.
Yeah, they got in trouble last time, like twice. Judge doesn't seem to be in that great of a mood today.
This is
He's
not
usually
intended to cause
jolly.
any embarrassment or discomfort. I simply want to ensure that the expectations for today's proceedings are clear. So turning to Ms. Seitz first, during today's hearing, what is your primary role?
Still photography, pool photographer.
All right, Mr. Dolan.
Video and pool video.
Have you read the court's February 25th, 2026
Oh, I
standing
bet
decorum
he
order,
has.
Ms. Seitz?
I have.
Mr. Dolan,
I have also.
thank you. And so do you understand the guidelines as they relate to your responsibilities today, including the as outlined in the decorum order?
I do.
Thank you.
I also do.
Thank you. Do you need any additional time to review the order or to reposition yourself or the camera to ensure full compliance?
I do not.
I do not.
This is a
Do
hearing.
you anticipate any difficulty complying with the order?
I don't.
I do not either.
All right.
But it's
Thank you
live.
to you both.
Thanks.
And I appreciate your cooperation today and that we can make this proceeding move forward smoothly. Fourth, I want to turn to the state as it relates to discovery and just want to see if we could have just a brief update. Mr. Grunander.
Thank you, Judge. Yes, for the record, we sent another batch of discovery to the defense as recently as last night. As far as the files that in our possession, we have provided 93.9% of those files to the defense at this point. We also, for the court's information, met with the defense yesterday, and part of the discussion centered on discovery, and we hand-delivered to them a hard drive containing information with respect to digital devices that had been seized as part of the investigation and analyses done by the RCFL, which is the Regional Computer Forensics Lab. That was a 24 terabyte hard drive. I don't imagine it was entirely full, but there was a large amount of information that was provided there. As I said, we met and talked about discovery. We talked about some of our expectations. We
Last
are
night.
candidly still waiting
Unreal.
for some information. We had a meeting yesterday morning with some of our federal law enforcement partners, the FBI, the ATF, and talked about this issue of discovery and impressed upon them the need to have everything in their possession. We were assured that it's coming quickly. The ATF.
He just said, "Is your audio distorted?"
Next week or so, that we will disseminate to the defense, and we believe that that will have all of the underlying data from in its original form that the defense could then use for their purposes with their experts. We are in the process also of reaching out to all of the local law enforcement agencies to ensure that we are in possession of all of the body camera footage from that day, as well as other information. We will continue to work on that. As part of our discussion.
Why did he mess with the mic?
Probably the primary purpose of the meeting with the defense yesterday was to forecast what we anticipated presenting at the preliminary hearing that's currently scheduled for May. As far as the individuals that will testify, as well as exhibits, we will be preparing, while it's not required under the rules, we are going to prepare.
I just want this to be on the record. I am not trying to come off as anti-Charlie. I'm extreme supporter of him. I want Tyler Robinson to have the most thorough and just trial possible so that there is no appeal process. And by giving discovery the night before hearing to the defense, that's egregious.
A witness list and an exhibit list that we'll disseminate to the defense with Bates numbers so that it could be easily found in the case file. We are also helping the defense to facilitate a meeting.
This guy's definitely getting
for
fired
them
after
to examine
today.
the physical evidence that's in the possession of SBI. We anticipate that probably happening next month when we're back here. I think April 17th. And then lastly, we did also coordinate a meeting to meet with the defense today, this afternoon sometime, to walk the UVU campus so that they can take a look at the scene.
Okay. Thank you, Mr. Gernander. I appreciate the details. Does any party wish the benefit of the record as it relates to the discovery? Mr. Novak.
Richard Novak for Mr. Robinson. We can either address this now or obviously later this morning as the court wishes, but there's a connection between the discovery that we have not yet received, that the Utah County Attorney's Office has not yet received, and going back one
I love having you here.
layer further, the State Bureau of Investigation has not received, which is directly related to our ability to meaningfully prepare for the preliminary hearing.
Okay.
And that is what I will generally describe as the federal forensic files. We're talking both about case files, as the ATF calls it, and data files from both agencies, which relate directly to forensic analyses, which led to forensic opinions, which it appears the state intends to move into evidence at the prelim through 1102. But we don't have much, I should say most of the underlying data. We don't have data that we've been able to give our experts on stuff that relates to those opinions. So we did meet and confer after yesterday's meeting about the fact that we need to ask this court to postpone the preliminary hearing for that reason. We can put it in writing if we need to do this by written motion. We can discuss it in more detail today. But it's not little tiny bits of witness statements here and there and reports and some photographs that we're missing. From our perspective, this is core fundamental data that underlies expert opinions that the state wants the court to consider. And we have no ability to either get our own expert opinions or meaningfully cross-examine the state's witnesses, or frankly, even call the forensic experts themselves, because we have a right to put on our own witnesses, because we don't have their data. And our experts can't advise us on the data if we don't have the data. So we can't meaningfully cross-examine, we can't meaningfully examine the state's forensic experts if the state decided to call them as live witnesses as opposed to through an 1102 process. And we can't be prepared to put on our own witnesses
question.
because they don't have the data. So I don't want to pre-argue it unless the court wants to get to the merits of that. I did go back and I looked at the court's comments back when the court set the May preliminary hearing date in December. And I don't think I need to read back to the court what the court said. But
Oh my God, this
that's our
videographer.
concern. So we can either, from our perspective, discuss what is a realistic preliminary hearing date based on the representations that we will get certain data in the next couple weeks, which there's total good faith from the state council. When they said
I'll
they
wait
met
for-
with the federal partners to impress upon them, I know what that means. That means they've done everything they can do, but there are federal agencies which haven't produced fundamental forensic data and files underlying very important expert reports. So we have the reports, but not the data. So we can either address that later today after the court hears the argument on the pending motions. We can move in writing
51 subs
set a
away
schedule for that. We are cognizant of the
from
fact that
2000.
last hearing the
Let's
court
do it.
said,
Thank
if
you.
I may, we've got a really busy calendar. We don't have any openings. So we wanted to bring this to the court's attention today, because if we just let this go and we file a motion and then there's a response and then there's a reply, and then I don't know when that hearing is going to be because of the court's calendar, that preliminary hearing date may be further out than these preparation issues require because of the court's calendar.
No, I appreciate that. I appreciate that heads up. And we'll revisit it at the end of this hearing. It's hope springs eternal in regards to discovery when it's passed over, and obviously the defense needs the necessary time to prepare as provided and the constitutional rights allow. And so I'm cognizant of that. So I appreciate the heads up, and I appreciate the work between the parties to move this forward. Let's revisit that at the end of today's hearing.
Absolutely.
Thank you,
Okay.
Mr.
Thank you, Your
Novak.
Honor.
Thank you. Thank you, counsel.
All right, well, let's turn to the matter that's before us. As this is the defense's motion, I will turn to you for your argument and your request. Just as a heads up, I battled
Yes.
cold, so if I take a drink of my water,
Tremendously.
it's to spare you from coughing or.
Oh, he's not feeling well.
No
Ms.
problem.
Visser.
Yes, thank you. I will be addressing the motion to classify the January 9th motion, kind of taking these in chronological order here. I know this court is kind of drowning in First Amendment briefing, so I don't want to delve too much into that aspect.
America.
Certainly, I'm open to answering any questions the court has, but
Thank you,
I kind
Lisa.
of want to start with just the very base level. We are asking the court to classify this motion and the attachments as private under Rule of Judicial Administration 4-202.04. The reason that we are asking the court to do this fundamentally is because we believe that the release of this motion and the evidence has a reasonable probability of impacting our ability eventually to impanel an impartial
This.
jury and for our client to have a reliable penalty phase should that occur. I want to start kind of with a little bit of a procedural history here.
Oh, great.
Back
historian.
In October, November, early in the case, the defense and the prosecution met and conferred about how the government would preserve evidence in this case. And when the government, the prosecution, and any law enforcement agencies sought to conduct testing that might impact the evidence in particular ways, they were to provide us notice. And if we could not come to an agreement about that, we are required to file something with the court to ensure that the testing doesn't move forward. That's what occurred here. In December, on December 22nd, we received notice from the state. They filed a certificate of service for that notice. And they also informed us in the correspondence, essentially, that they were not filing the notice because they were concerned about their ethical considerations under Utah Rule of Professional Conduct 3.6, which basically says we should avoid making public comments that influence a case. And the comments specifically talk about particular evidence that might impact a case, more likely to impact a case. We agreed with this. We did try to come to a resolution, but ultimately, at the end of the day, we needed to preserve the issue. So in order to preserve the issue, we had to file something with the court. And honestly, there was a lot of back and forth about whether or not we could file it publicly, how we wanted to do that, because we have the same concern that the state voiced in that initial email. Are we putting something into the public sphere that will inappropriately enter into the minds of potential jurors and impact the case? Ultimately, we decided that we have two obligations. One is to preserve the issue, to ensure our client's right to due process and his right to effective assistance of counsel needed to be preserved. We needed to file this and put the court on notice in a way that this court can make a ruling on it should that become necessary. And I will say, Your Honor, that we continue to work on this issue with the state. We're still negotiating it. We are not asking for a hearing on the underlying motion because we think we can likely resolve it. It was almost to the point where we contemplated potentially asking to withdraw the motion, but of course that doesn't really cure the record issue. So we are here. In addition to that, the other obligation, of course, is to ensure our client receives a fair trial. So we filed a motion to classify. When we filed the motion to classify, we did notify the state, and they took a slightly different position. They basically said, well, now that you filed it, we don't have the same concerns under Rule 3.6. I think those concerns remain. I don't want to talk about the evidence specifically in a public setting, so I'm going to choose my words carefully and maybe read a little bit more than
Yeah,
I
this
normally
sounds like a
would.
disaster waiting to happen, ma'am.
But the evidence is important enough. It is important. It is evidence that will be at issue in the case. But it is also in process, which is the whole point of the underlying motion, right? It's in process. There is more to be done. There is more the state wants to do with that evidence. So it is not in a place, in a position where we are going to be arguing about admissibility because it's not done, right? So what we're talking about is releasing preliminary evidence into the public sphere that has the potential to impact jurors.
48 subs away from
And
$2
it
grand.
is
Let's go.
important enough that we are concerned that it will sway people's opinions one way or the other. And I want to make clear that our concern here with selecting an impartial jury, really, it goes both ways, whether the evidence is good for my client or bad for our client, whatever it is, it makes it harder to find impartial jurors if they are entrenched in an opinion about our client's guilt or innocence, either way. So we don't want to be putting out evidence as the defense that will sway the public opinion. We've already told the court, we're not fighting this case in the public. We're not trying to sway the public in favor of our client's innocence. That's not what we're doing. So,
Thank you, Mitchell. I know you guys are out there. Just hit that subscribe button. It's
I
free.
also
It
want
helps.
to address one issue that I've seen generally arising in this case, and I think it deserves some comment. There seems to be an idea that flooding the public sphere with information or evidence from this courtroom will somehow dispel conspiracy theories or shift public narrative. That in and of itself is concerning to the defense. No one should be worried about that. All we should be worried about is protecting what happens in this courtroom. We believe that preemptively releasing evidence that we needed to provide to this court in order for this court to make an informed decision is just one of those actions, is one of those things that will negatively impact our ability to have a fair proceeding for our client.
Highlights only.
So we are asking that the motion and the evidence be classified as private, that this court consider our client's unqualified right to a fair trial and a reliable penalty phase should overcome the qualified right of access at this point. We understand things may change. This evidence may come in other ways at other points in the proceedings, like a preliminary hearing.
I mean, I
or
do
when we
live
actually
trials, but
challenge the admissibility of evidence. But at this preliminary stage, we believe this is the appropriate course to take to protect the proceedings and our client's rights. Does the court have any questions for me?
Well, I do, but I'm going to wait till all of.
yeah, you can tell he's sick today.
Is there another attorney that's going to be presenting?
Yes, Mr. Burt is going to present on the other motions to classify and the motion to close the hearing in part on April 17th if the court is prepared to hear that.
All right. Yeah, I want to hear all of it, and then I'll have questions for you all. Thank you, Ms.
Sure.
Visser. Mr. Burt.
Sure. I usually just do highlights, so this is
Michael
so
Burt,
slow.
Mr. Robinson. I'm going to be addressing the motion to classify what I'll call the camera motion, the motion to restrict electronic media. So there's a motion to classify that motion as private. And then there's a motion that was recently filed to close the select portions of the hearing that is scheduled for April 17th.
Mr. Burt, just for clarity, would you mind referencing the docket number of these motions?
April
Certainly.
17th.
And for Ms. Visser as well. I just want
I need to
to
write that down.
make sure we're tying it well in the record. So,
Yes.
because sometimes we use different terms about talking about the motions, and if we use the docket number in conjunction with that, it just clarifies it for everyone's benefit. And I didn't mean to catch you off guard or.
No, not at all, Your Honor. So let me take it chronologically. The motion to classify, motion to exclude still photographers, TV cameras, and microphones from the courtroom as private. That's docket number 310.
Thank you.
Then the motion to close portions of the April 7th hearing is document 425.
Thank you.
And there are, of course, oppositions to those motions. If the court would like, I can outline what those are.
No, I'll have the other side. I don't want to deprive them of the opportunity to do the same thing as you just did.
So in all, there's a lot of paperwork in front of the court. And
Sure.
obviously, I'm not going to repeat everything in there. But one of the cases that's cited by all parties, I think, is the Utah Supreme Court opinion in Kearns Tribute Corporation, which is 685 Pacific 2nd, 515. And there are a number of key points in that opinion that I'd like to focus the court's attention on. And as the court may recall, the issue there was whether there was a public right of access to a preliminary hearing. And one principle the court sets forth in the opinion is at page 519, where the court says, we believe the issue, quote, we believe the issue should turn on the precise nature of the proceedings in question. We limit our review to cases involving preliminary hearings. And then the court proceeds to explore the nature of a preliminary hearing and decides that because of the nature of that preliminary hearing, it, like the trial itself, should be classified as one that the press and the public have a right of access to. And
The
key
hearing
portion
on
of
that is in
discussion
April.
is at the following page where the court says Utah's preliminary hearing is different from the preliminary hearing in some other jurisdiction in that it does not include hearings on motions to suppress evidence. Rule 7D1 provides, and then it quotes the rule, and the court goes on and says, as a result, the added risk of prejudice through pretrial disclosure of evidence targeted in a motion to suppress are not present in Utah's preliminary hearing. If the prosecution elected to try to use such evidence in the preliminary hearing in advance of a ruling on whether it should be suppressed, the defendant could seek special measures to avoid its public disclosure. So there, I think the court is signaling that in a preliminary hearing context, if an issue of inadmissible evidence comes in, the
I have two streams
appropriate
going.
procedure is for the defense to seek closure of at least that portion of the hearing where the evidence is going to be discussed. So the first point I wanted to make is court looking at the procedure we're asking to close a portion of, and that is the motion to preclude further electronic media coverage of the case. It is unlike a preliminary hearing in the sense that that hearing on the 17th is not going to include a motion to suppress evidence, obviously. It's going to include a discussion of the nature and extent of prejudicial pretrial publicity. And I emphasize prejudicial pretrial publicity because the cases define that term as a term of art. It does not include all pretrial publicity. We are not complaining about all pretrial publicity. We're complaining in that motion to close the hearing, which is the motion to prevent further electronic coverage. That's document 305. Our only focus there is on what the courts have characterized as prejudicial pretrial publicity. And that categorization includes the same type of information that Rule 3.6 prohibits lawyers from commenting upon. Things like confessions, things like evidence before it's been admitted, personal opinions as to guilt or personal opinions as to the appropriate penalty, evidence which is clearly inadmissible. Those are the categories of prejudicial pretrial information that the courts and the rule focuses on. So our motion to preclude further electronic coverage details.
A lot of people
and
do.
The media says in too much detail the kinds of prejudicial pretrial publicity that have characterized this case so far. So the hearing and the standards that the court is governed by under the rulings that we cite, particularly the James case, the Utah Supreme Court case says, in deciding whether there's a reasonable likelihood of prejudicial pretrial publicity, the court has to consider a number of factors. And one of those factors, the size of the community, the nature and extent of the pretrial publicity. So as part of our burden, we have to show the court through evidence what is the nature and extent of the prejudicial pretrial publicity. And by definition, that prejudicial pretrial publicity is inadmissible at trial. So we're not dealing with a situation where the court has not yet ruled on a motion to suppress. That issue comes up in relation to the other motion that Ms. Visser just talked to you about. we're dealing with a motion that by definition is putting forth in front of the court evidence which is clearly inadmissible at the trial of this case. Confessions, alleged confessions, opinions and statements by Ms. Kirk, statements by the President of the United States, statements, opinions by the Vice President, by the Governor,
What about the text?
prosecution, by law enforcement officials. All of that prejudicial pretrial publicity is by definition inadmissible evidence. So in that kind of a hearing, is that the type of hearing that we're going to hold on the 17th that should be subject to a right of access? The first issue which Kern says the court should consider. And my argument to the court is that it's not. It's not a traditional procedure such as a trial or a preliminary hearing where courts have recognized a right of access. But even if there is any sort of right of access to a hearing on whether the media, electronic media, should be excluded, the nature of that hearing has to be considered. And as Kern dictates, I think the best description.
Sorry, my
of
Frenchie's snoring.
the type of hearing we're talking about on the 17th is discussed by the U.S. Supreme Court in Estes versus State of Texas, which we cite in our 305 pleading. And in that case, like this one, there was extensive pretrial publicity, prejudicial pretrial publicity. And in that case, like this one, there was a motion to exclude further coverage by way of electronic media. And the court addressed the issue of whether that type of a hearing is something that in itself can give rise to prejudicial pretrial publicity because of the fact that the evidence that's being brought forth during that hearing is going to be by definition prejudicial. And the court in
Can you
essence,
hear her?
this is
If you
Judge
can, I'm going to mute
Clark's
myself.
opinion, says, is it page 535 of the Estes opinion, it is contended that this 2-day pretrial hearing, that is the hearing to exclude the press, cannot be considered in determining the question before us. And the question before them is whether Mr. Estes was deprived of his right, federal constitutional right to a fair trial. The court goes on, we cannot agree. Pretrial can create a major problem for the defendant in a criminal case. Indeed, it may be more harmful than publicity during the trial, for it may well set the community opinion as to guilt or innocence. Though the September hearing dealt with motions to prohibit television coverage and to postpone the trial, they are unquestionably relevant to the issue before us. All of this 2-day affair was highly publicized and could only have impressed those present and also the community
Okay,
at
thanks.
large with the notorious character of the petitioner as well as of the proceedings. The trial witnesses present at the hearing, as well as the original jury panel, were undoubtedly made aware of the peculiar public importance of this case by the press and television coverage being provided, and by the fact that they themselves were televised live and their pictures rebroadcast on the evening show. So that kind of captures why we had to bring this motion, because we don't want to be in a position of inflicting another wound on Mr. Robinson's right to a fair and impartial jury by republicizing either right now in arguing this motion
Welcome.
or on the 17th when the court hears from us what the nature and extent of that pretrial publicity is.
Well, let me stop you right there, Bert, and
Yes.
Mr. Bert. So you cite the Estes case, but Estes was overruled by Chandler v. Florida because in Estes, there was an assumption of prejudice. But in Chandler, it required the defense prove actual prejudice. And so it changed a little bit. Can you talk a little bit about that?
Yeah, certainly. The Chandler court, first of all, was asked to, but did not overrule Estes. But what it did clarify, as the court just indicated, is that if the defendant wants to prove up a federal fair trial violation, it's his burden to prove prejudice. And the Estes court outlines that.
Oh,
that
wow,
will be
guys,
done
hit the
through
like
an
button,
evidentiary
please.
hearing
We really need
at
it.
which the defense would have the burden of showing, again, the factors under the James case, nature and extent of publicity, how it prejudiced the defense, whether there are reasonable alternatives. That's going to be the very purpose of the hearing, to comply with Chandler's mandate that we have the burden to prove that prejudice. And so we're going to be taking on that burden, and we think well establishing that we're entitled to the relief that we seek, which is some restriction on the type of prejudicial information that is flowing not only from the electronic media, but that electronic media being amplified by the widespread use of social media, which we discuss at length in the motion. I'm not going to get into the merits of the motion itself, but
Thank you.
to address a concern the court had about, well, really Estes is no longer good law. Estes is cited favorably in Chandler. It's cited favorably in Hollingsworth versus Perry, which is the Supreme Court's most recent discussion of cameras in the courtroom. And the court is correct that Chandler put a gloss on it, that we have to show there is no presumption of prejudice, but there is a presumption of prejudice in regard to certain types of prejudicial pretrial publicity. And the clearest holding to that in that regard is the Schilling case. Schilling says there is no presumption of prejudice unless certain categories that the courts have recognized as prejudicial are proven, and then it's inherently prejudicial. And the example that Schilling cites is publicity about a confession. And it cites back to the Wilbert Rideau case, Rideau versus Louisiana, where the court reversed the conviction because the defendant's confession was broadcast prior to the trial. So we have that type of prejudicial pretrial publicity in this case, and it's outlined in the motion. And so, yes, if you don't have those categories of prejudicial pretrial publicity, you have to prove prejudice. But there are certain well-known categories that do give rise to a presumption of prejudice. And that's reflected also in Rule 3.6.
He's the talker.
Says there's certain things lawyers should not be commenting about. And so we'll show both that we have categories of prejudice that are recognized as presumptively prejudicial, and we'll show that beyond that, the overall picture of this case is one of extreme prejudicial pretrial publicity that justifies the kind of relief we're asking for. But how do we show
I think he's
that
towards the end.
without re-inflicting the very harm that we're seeking to avoid here? And that's the purpose of our motion. And the
Did you
main
hear the
concern
judge? He went, okay.
is the tendency in this case for the press to, first of all, highlight all of the prejudicial information in virtually every story they feature on the case, which has its genesis in the prosecution's initial press conference before the court imposed its publicity order. There was an extensive press conference which got before the public a great deal of the kinds of evidence which Rule 3.6 says
It's extremely
should not be
rare
disclosed
to not
before the
have
court makes
cameras in a
decision to enter into an
courtroom
order.
for a criminal
And then
case.
that evidence has been re-amplified, commented upon, so-called experts have been brought in, lip readers, body language experts, all of that is outlined
Get
in the motion.
real.
The kinds of reiteration of this prejudice that we're most concerned about, the
Lip
best
readers.
example of that in document 344, which is the reply brief on this closure issue. At page 6, there is a link to an article. And that article concerns a story by one of the media's clients in which they were supposedly reporting on a defense anticipated motion to modify the court's publicity order. And the story does not concern, it's a television story, and the court has to see it to understand what the issue is. But the story does not concern what the merits of the motion is. The story focuses on, let's repeat for our audience in a very dramatic fashion all of the prejudicial statements made by politicians from the president on down, characterizing Mr. Robinson.
I would
as
never
an
ask this
animal,
man
characterizing
to
him
repeat a
as
story to me,
evil,
ever.
characterizing him as deserving
Nope.
of the death penalty. And they string together all these quotes and rebroadcast them. And that's the kind of coverage that's, I cite that as one example. But if the court sat down and touched on all the links we have in the 305 motion, the court will see it's repeated over and over again. So we don't want to be in that position of putting in front of the court all of this prejudicial information and having the press regurgitate it yet one more time and
One more
re-inflict the
time.
wound that we're seeking to avoid. That same link to that same article is in document
I know, right?
305 at page 175. It's interesting that the media's answer to this
Let me go through my 900 pieces of paper that I don't have organized in
discussed, but
any way
it's
whatsoever.
interesting to return for a minute to the Kearns case. To continue with the other points that I wish to emphasize from that case, the third point from that case is the standard that governs what we have to show. And the court, in the opinion, says we don't have to show a clear and present danger to Mr. Robinson's right to a fair trial, but a realistic likelihood of prejudice. That's the standard the court will apply. And if the court looks at the standard for excluding electronic media, it's similar: reasonable probability, reasonable likelihood of prejudice. That's the applicable standard the court will apply. And the court also outlines the procedure to be followed on the motion that we're conducting right now. That is the motion on the hearing of whether the proceeding should be closed. And the court says, first, the hearing on the motion for closure should be open to the greatest extent possible, referring to this hearing that we're conducting right now. And then the court says, second, if disclosure of the alleged prejudicial material is essential to the conduct of the hearing on the motion for closure, the court should first seek a voluntary agreement from the parties who wish to be present that they will not disclose the alleged prejudicial information until it is disclosed at the trial or the trial has concluded. Absent such an agreement, the court may close the courtroom in order to conduct in camera whatever proceedings cannot be conducted without
I had to update
disclosure of the allegedly
gold money.
prejudicial information. So as I read that, the court's referring to the people presently in the audience who wish to be present during this hearing today, and that if they can't promise that they will not use information that I want to disclose in support of the motion today, then the court should conduct procedures in camera. Now, is it necessary for me to disclose to the court what my prejudicial information is? The media says in their motion
Oops.
that they filed yesterday, which is, I don't think I have a docket number for this.
This
but
is
it's
the
entitled,
accused shooter
"News
of
Media's
Charlie
Memorandum
Kirk.
in
He
opposing
has a
motion to close
hearing,
portions of the hearing,"
and his defense doesn't want
filed on
people
12th yesterday. I
videotaping
don't have the
like
docket
the
number. I'm
media
sure the media
involved,
does, if there is one.
which is crazy.
But what they
Freedom of
say
press,
is
like
it's
First
really not
Amendment.
necessary for me to disclose to the court all the prejudicial information that we're relying on to justify moving to
Oh my
close because at page 2, they
Right.
say, if the defense does not want to highlight certain information at the evidentiary hearing, it can choose not to. The information is already cited in the motion to exclude, so the court can find it there. That would be a good solution, except for the fact that the media is also opposing our request to keep the motion private.
48 more
So it
subscribers.
doesn't
Come on, guys.
do
Please
us
hit
any
that
good
button.
to refer the court to all the prejudicial information in the motion if the court accepts the media's position that that motion in itself has to be disclosed to the press. Because if it is disclosed, they're going to take that motion and they're going to reiterate all the highlighted prejudicial information in that motion. And again, defeat the very purpose of filing the motion.
Cooked. Deep
A
fried.
couple of other points that I wish to emphasize to the court.
Oh, welcome.
One
You are
is-
so welcome.
In both the present motions that I'm talking about
Please hit that. and
and
subscribe.
the motions that Ms. Visser just responded to, the media and the state, and the state are in, and the media are mini-me's of each other on this issue. Their pleadings are virtually identical, which calls into question why the media is even a part of this hearing.
Oh
The
my
court has
God,
not
are
yet
you
decided
kidding
whether they
me?
have standing on this particular issue. And in your December ruling, you said that we were not obligated to file with the media the motions concerning restricting electronic media. In their latest opposition to the closure motion, they discussed their standing. But one of the issues in standing is whether we need the voice not only of one media lawyer, but of two media lawyers asserting the same position that the state, one of the parties in this case, is asserting. So you're being presented with three different lawyers arguing essentially the same position. And
Oh my God.
the court
Facts.
denied intervention to the media in this case.
I don't even feel bad
Cited
talking over him at
the,
this point.
Utah Supreme Court decision in Society of Professional Journalists of Utah versus Bullock. And there the court, Utah Supreme Court, addresses the issue of standing in detail. And and there were multiple media agencies in that case. And one of the points the court makes is that although there are multiple media agencies, they're all representing the exact same interest. That is the interest of the public in open access to the proceedings, which is coincidentally the same interest the state is asserting in reference to this motion. So we do question whether the state even has standing, but
You mean the
putting-
press?
I mean the press.
All right.
I'm sorry, I misspoke. But putting that aside, both the state and the media stress to the court that the court should deny the motion to close, should deny, obviously, the motion to restrict media access.
Who, Mitchell?
And allow the kind of prejudicial publicity that has characterized the case to continue.
Sorry.
because
Frenchy
we can
problems.
all sort it out at trial through venue, motions for change of venue, through voir dire, or motions to expand the jury pool. And I wanted, that issue is addressed in detail in our underlying motion, the lengthy motion. But just to highlight a couple of the points that we raised there, one of them is the Utah Supreme Court in a case that Ms. Nestor is currently involved in, the Richins case, and this is cited in our motion,
The what
said that the
case?
court does not have the authority to expand the jury pool. So that remedy is not one the court can adopt. And in terms of the other remedies that are being suggested, neither the state nor the media cites what I think is a controlling case on this issue, which is Gentile versus State Bar of Nevada, which is 501 US 1030, discussed in our motion. But there, Chief Justice Rehnquist, writing for the court, who is no
He's in filibuster mode.
fan of the criminal defendants, said,
I'm going to set up a
quote,
goal.
even if a fair trial can ultimately be ensured through voir dire, change of venue, or some other device, these measures entail serious cost to the system. Extensive voir dire may not be able to filter out all of the effects of pretrial publicity. And with increasingly widespread media coverage of criminal trials, a change of venue may not suffice to undo the effects of statements such as those made by petitioner. So I don't know how many capital cases the media lawyers have been involved in, but for the last 40 plus years, I've done nothing but those trials. And I've been involved with using jury questionnaires, extensive individual sequestered voir dire. And the fact of the matter is that voir dire is not an effective means in these cases. And to the extent it is effective in excluding people who hold prejudicial opinions, it calls into question other rights that are implicated. For
Oh, thank you,
instance,
Whoopsie.
in a death penalty case, the jury has to be death qualified, both those who would automatically impose death and those who would automatically impose life. And there's a lot of research. This is an issue which will be explored down the line, but there's a lot of research which shows that that process skews the panel as unrepresentative. It excludes people who are knowledgeable because they read this media coverage. It excludes, the evidence shows, minority groups, women, and people that normally would be included in a representative jury. So yeah, you can void dire a jury on whether they've heard the President of the United States say that Mr.
Is the
Mr.
greatest
Rosen
of all
should be executed.
time.
And you can exclude that juror from serving on this case. But given the demographics of this county, you're going to be excluding
Mormon,
a large
Mormon,
portion
white,
of the
Mormon,
population. And then
white.
when you add to that the death qualification process, you no longer end up with a representative jury. You end up with what the U.S. Supreme
Welcome,
Court
everyone.
in
Please hit the
Witherspoon
thumbs
versus
up.
Illinois called a group organized to return a death verdict, but it's not a representative jury. So as Chief Justice Rehnquist said in his opinion, even if you employ these other means, they come with a great cost, and in this case, a great constitutional cost. So those are the main points I wanted to make to the court, and I hope I haven't repeated things that
Sir,
I'm already familiar with, but I'm
please
certainly happy
sit
to answer any
down.
questions the court
Sit
may
down.
have.
Well, what I think I'm going to do is wait till the state makes their argument, and then I'll have questions. That's going to put the picture together for me,
Great.
and then have questions for all parties. I just want to make sure I hear it all, and I appreciate your arguments, Mr.
Makes
Burton.
sense. Thank you, Your Honor.
Turning to the state.
Kimberly, I like that that logic. But I feel like people who do these sort of things, alleged
Your Honor,
people,
Christopher Ballard on behalf of the state. First of all, let
Do
me
it
just set the table
for
the
attention.
court, because I think there's a motion pending the defendant didn't mention, and that's the motion to classify the reply brief in support of their motion to exclude cameras. Would Your Honor like that docket number?
Yes.
That motion is docket number 400. So as I understand it today, we've got 4 motions in front of the court, 3 of them dealing with classifying documents that have been filed. First is the January 9th motion.
You have to say that's
Then
funny.
we've got a motion to classify the motion to exclude cameras, which Mr. Burt has just addressed. A motion to classify the reply in support of that motion to exclude cameras, which I just mentioned is docket number 400. And then also a motion to close portions of the hearing in April that Mr. Burt has also addressed. So it's my understanding that we're here on those four motions. Would it be helpful for the court for me to give you the state's opposition to those motions, the docket numbers for those?
That would be helpful, Mr.
Okay.
Fowler. Thank you.
Sure. So on the January 9th motion, state's opposition is
wind.
docket 340. On defendant's motion to classify the motion to exclude cameras, the state's opposition is docket number 346.
Should I write this? I feel like I should be
On
writing
the
this.
defendant's motion to classify the reply supporting its motion to exclude cameras, the state's opposition is docket number 431. And then on the motion to close portions of the April hearing, the state's opposition is docket number 448.
Thank you.
I think part of the problem with this is on three of these motions, we don't have any requests to submit. There is a request to submit that the media helpfully filed on the January 9th.
I wrote them down.
And that lists all of the docket numbers of the relevant documents. There's been quite a few on that one. So hopefully that's helpful for the court.
Yes.
You guys love
The next
this.
thing I want to clarify is the standards that apply to these two different categories of motions. The defense here has not been very careful about articulating and applying the correct legal standards that govern these motions, because there are different standards that apply to classifying documents as opposed to closing a hearing. The standard that applies to classifying documents is found in the Utah Rules of Judicial Administration. That's Rule 4-202, .04. But the standard that applies to closing a hearing, as the state explained in its opposition, is governed by case law. And that's the Kearns Tribune case and subsequent cases following that case. And then I also
Come
want
on.
to just clarify that Rule 3.6 of the Rules of Professional Conduct that's also been mentioned, that rule, while it might be relevant because it talks about pretrial publicity, it does not govern any of these motions. Because Rule 3.6 talks about lawyers making extrajudicial statements. We're not concerned about any extrajudicial statements in any of these motions or in closing the hearing. Obviously, everything that's going to occur in the hearing is going to occur in court. And I also just want to emphasize that Rule 3.6 makes it clear that there's nothing improper about a lawyer commenting on information that's contained in a public record like the information that's filed in a criminal case. Now, with respect to the first motion
You want to sit with me?
to classify defendant's January 9th motion that has to do with the evidence, the state did mention Rule 3.6 when it submitted its notice of intent to test evidence. The state did that because the state recognizes that under Rule 3.6, there can be concerns about statements that deal with evidence and testing and results of tests. Our hope, and I guess it's proved to be overly optimistic, was that if we could do this without having to file something in court, we could get this issue resolved of whether we could go forward with the testing. We'd get that resolved. We wouldn't need to be here in a hearing like this today, arguing about whether something needs to be public or private. We could
Don't
hopefully move forward, get the testing done, and get us that much closer to trial. The state was not suggesting that there would be anything improper about filing a motion and having this type of evidence listed in a public document. So that was not the state's intent in originally mentioning Rule 3.6. We were just recognizing that there could be concerns, and hopefully, in hopes of avoiding any kind of hearing like this and getting this issue resolved as far as the testing goes, that we could move forward. But we find ourselves here. Now, another thing I want to clarify is we are not media lawyers. We are not
Don't
representing
forget
the interests of the
anything.
Media. Our client is the people of the state of Utah, who do have an interest in the public nature of these proceedings.
Yeah.
But whether any particular document in this case is public or private is really of secondary concern to the state here. We're not trying to represent any kind of media interest, and I think it's improper for the defense to suggest that. Although maybe the media might want to hire us because we probably charge much lower rates than the media lawyers. But we're not representing the media's interests. We are just, our primary concern is moving this case forward and applying the correct standards. in the law.
46 more
So
people
with
need
that,
to
let me
sub,
turn
please.
to the substance of our response to the motion to classify the January 9th motion. It's clear from the rules of judicial administration that that document, having been filed with the court, is a presumptively public document. And a general allegation that it discusses evidence that might be inadmissible is not enough to deny public access. If that were enough, then any motion that discussed evidence before there was a ruling on the admissibility of that evidence would have to be private. And even if there were some basis for ultimately finding that the evidence discussed in the motion was inadmissible, public exposure to that kind of evidence does not necessarily justify or it does not necessarily prejudice defendant's right to a fair trial and justify sealing that document. And the controlling case of State versus Allgaier here from the Utah Supreme Court in 2011 is very instructive on this point. It's instructive to all of these motions. Allgaier was a capital case. And the issue in Allgaier concerned a letter that was sent to the court from a fellow inmate of Curtis Allgaier, the defendant in that case, who'd
Don't
been
bite
charged
me.
with capital murder. And the letter stated that the defendant had confessed to aggravated murder and also threatened the inmate and the inmate's mother if the inmate revealed that confession. I can't imagine any more potentially prejudicial information in a capital case. It's a clear admission of guilt. It's a clear admission of future dangerousness. So the defendant in that case obviously wanted to keep that letter private, but the court denied that request because that information that was in the letter was already contained in the public record. Now that fact is not necessarily relevant to this motion to classify the January 9th filing, but it is relevant to the rest of the motions here. But what the court said next in affirming the trial court's decision in Allgaier to release that letter is really instructive, because the court recognized that despite already circulating reports of highly prejudicial information, there were alternatives to restricting public access to the document. And those reasonable alternatives are the time-honored tools of jury selection.
Very
That's
good
how we
question,
screen out
Buff.
jurors whose prior knowledge renders them unable to objectively view the evidence. And I think it's interesting in Allgaier that the court said those tools would be effective to protect the defendant's
Thank
right
you,
to a fair
Kimberly.
trial, regardless of whether how that balancing came out, whether the court said, yes, this is so prejudicial, it shouldn't be released, or the risk of prejudice is not high enough to justify
I just don't
restricting
know.
access. That ruling, that holding in Allgaier coincides perfectly with the United States Supreme Court's analysis in the case of Press Enterprise 2, where they mentioned as well that through voir dire, a court can identify those jurors whose prior knowledge of the case would disable them from rendering an impartial verdict. And as far as this notion of the court can't expand the jury pool, that's certainly not the case. The court can summon as many Utah County jurors as it deems necessary to be able to seat a fair and impartial jury.
We're almost
What happened
50
in the
people
Richins
away
case
from
is that,
2,000 subs. Please hit
given
that
Summit
button.
County is a smaller population county, they tried to expand the Summit County jury pool with jurors from Salt Lake County. And there's nothing that allows you to take jurors from a different jurisdiction and add them to the jury pool. But we're here in the second largest county in the state. There's not going to be any problem with expanding the jury pool here. I'll just briefly touch on, as far as the other two motions, to classify the motion to exclude cameras and the reply in support of that motion.
Sorry, guys.
I think basically the same arguments apply. The only thing I would add there too is that this idea of where there's so much media coverage that you've got to necessarily find that there's some prejudice. I don't know that it necessarily works that way. I think that the fact that media coverage becomes so pervasive can also tend to dilute the effects of that media coverage, because when something becomes a constant drone, a lot of people tend to tune it out. Now, for sure, there'll be people that are fixated on this case, but we weed those out through careful questioning during voir dire. And I also point out that not all media reports in this case have been unfavorable to the defendant and favorable to the state. It's gone both ways here. There's media that the state's concerned about as well. So just saying that this is a content tornado or there's been a barrage of media coverage doesn't necessarily mean that there is going to be prejudice to the defendant.
I would agree with that.
I'll turn then finally to the motion to close portions of the hearing. And again, there's a different standard that governs that motion. It's not governed by the rules of judicial administration. To close a court hearing, a court has to look at the specific nature of the proceeding at issue and determine, first of all, whether there's a presumptive right to public access to that type of proceeding. Now, defendants waived any argument that there's no presumptive right of public access because he hasn't argued otherwise. Instead, he's assumed that there is a right to public access and has argued for the court to close that hearing. But again, defendant has incorrectly relied on the standards that govern classifying documents rather than the standards that govern closing a court proceeding. But the same arguments still basically apply, that the defendant would have to show that the closure is necessary to protect his right to a fair trial. And we don't believe that he could make that showing where most of the documents or most of the evidence that's going to be discussed at that hearing is already public. And that's where that other portion of the Allgaier case comes in. If you're going to be discussing things that are already public, that tends to favor keeping the proceeding public rather than closing it. Now, the state does agree with the defendant on 2 points in that motion. To the extent that the hearing is going to discuss media coverage that has violated the court's decorum orders, we would agree that those portions of that hearing should be closed because that would be just committing further violations of the court's decorum orders by repeating that evidence. And then defendant has also mentioned that there are personal privacy concerns to some people and that they want to discuss media reports that have created concerns about personal privacy and safety, and the state would agree that those concerns are sufficient to justify closing the hearing. So we would agree with the defendant that portions of the hearing that discuss decorum order violations and that implicate personal privacy and safety, those should be closed, but otherwise, that April 17th hearing should be open, especially where it's just going to be talking about things that are already public. Does Your Honor have any other questions?
Not just yet. Thank you, Mr. Ballard.
Thank you.
Any other argument?
Yes, Your Honor.
Thank you. And counsel, remind me your name.
Different location that was completely irrational because
And for Your Honor's
they'd never do
benefit,
it.
I
I'd be like
intend to
San
handle the argument
Francisco.
On the motions to classify, and Mr. Judd intends to handle the argument on the motion to close the April 17th hearing.
Thank you.
So I'll start with the motion to classify the January 9th, 2026 motion. That's docket 285. And for the court's benefit, the news media oppositions are at docket 302, docket 337. And then we also filed a supplemental opposition on March 10th. I don't believe that has been filed on the docket yet because we filed it under seal and there wasn't a way for us as non-parties to file it on the docket. I will note that I do think the court granted our motion to file under seal, but it looks like the motion that was sealed, the opposition that was sealed was, I think, the incorrect opposition. I think the sealed one was docket 451, and that should have been kept public, whereas the one we sent to the court via email is the one that should be sealed privately.
Thank you for that clarification.
Yes, and we can clarify it again later if that's helpful. So starting with the motion to classify the January 9th, 2026 motion. And before I get into our arguments, I'll just clarify that I don't intend to comment on sort of the substantive arguments in the motion or the underlying evidence referred to. So as the state argued, filings are presumptively public. That's in the rule, it's clear as day. I do want to differ from the state a little bit though. So Rule 4-20202 sort of explains what the court needs to do when it's deciding whether or not to keep a filing public or to allow it to be sealed. What that rule doesn't exactly do is tell the court what sort of is the standard that it's applying when it's weighing the interests. And for that standard, I would refer the court to Press Enterprise 2. That's 478.
Did this
US
girl
1. And I
intern
know Mr.
under
Ballard
Wendy
talked about this
Lewis?
a little as well, so I won't go into too much detail. But that's the case from the U.S. Supreme Court that was
From the
decided
Kouri
after
Richins
Phoenix
trial?
Tribune, which the parties already referred to. And in that case, the court said that when a court is deciding to close a proceeding, so it wasn't referring to filings or documents specifically, but it was talking about a proceeding like a preliminary hearing. It said the court has to make specific findings and there has to be a substantial probability that fair trial rights will be prejudiced. And the court was very clear that the standard is substantial probability. And then the court also said there has to be no less restrictive alternatives. So that really maps nicely onto Rule 4-20202. The only difference being that in Press Enterprise, the court clarified the standard is substantial probability of prejudice. And although that case was referring to hearings,
It seems
open
that way.
hearings and open court filings are just two sides of the same coin.
I just have
They're stemming
allergies.
From the First Amendment, they protect the same interests.
Maybe they do
So
too.
there really is no need for the court to consider or apply a different standard for open filings or open proceedings. It can really be that Press Enterprise 2 test. But really, whether you're looking only at Rule 4-20202 or whether you're looking at Press Enterprise 2, the outcome for this motion in particular is the same. And that's because, as Mr. Ballard referenced, filings are presumptively public, and that doesn't change just because the court hasn't ruled on the admissibility of the evidence.
Not a winner.
You can look at, for that standard, you can look for cases like State v. Archuleta, that's 857 P. 2nd 234. That's the Utah Supreme Court. Also the Algier case, 2011, UT 47. There, the defendant made the argument the letter would have been inadmissible, and the court still said it should have been made public. And then also even United States versus McVeigh, which is a case cited by the defense, and that's 119 F.
Ballsy bringing that up.
And that's a 10th Circuit case. And then I finally, just the final point I want to make on this motion is the arguments from the defense about why this motion needs to be kept sealed are really quite generic arguments about pre-trial evidence. They could have been applied in any type of case to any type of evidence. And I understand that the defense is being careful because we're in a public setting. I understand and appreciate that. But the arguments in their sealed filings were just as generic and just as applicable to any type of pretrial evidence. And as we argue in our supplemental opposition, we don't think the actual arguments made in the motion justify that this type of evidence needs to be kept.
This is what I've been thinking in my
If
head
Your Honor has any questions about that motion to classify, I'll move on to the next.
until this is ending or over,
So the
rather.
next two motions to classify are relating to the motion to exclude cameras. And that is dockets 310, that's the motion to classify the primary motion. And then docket 400, which is the motion to classify the reply in support of the motion to exclude. And the news media oppositions can be found at docket 323 and docket 429. So for these motions in particular and the reply, I just want to make very clear that you cannot make public information private by putting it in a court filing. That's because filings are presumptively public, but also because, again, the information is public. You can't take a public thing, put it in a public forum, and it suddenly ends up being private. That just is not how the rule works. There has to be some sort of showing as to why this information can't be made public, but again, it already is public, including, in fact, information that was created by the public. So if the motion to exclude is kept private, what that's saying to the public is you can't have access to information that you in fact created. Similarly, the court cannot prohibit the public from discussing information that is already public. That is a prior restraint on speech. If there is news articles, if there are comments from public officials, the news has a right to report on that. The court cannot control that. So making this motion and this reply private or sealed, that's just not something that can actually control the speech. So this attempt to sort of control the public discourse, it's just ineffective, and it's also unconstitutional because it is a prior restraint on what can be reported on. The defense's argument there is that they shouldn't have to republish the information, but nobody is asking them to republish the information. They have decided to assert these arguments in the motion. They have decided to include all of this evidence. That was their decision, and they put it on the court docket. So the presumption is that it is public. And
I have a
the news
bunch
media in our
I'm
opposition
going to
to
do
that
for
motion,
members only.
not the motion to classify, but the motion to exclude cameras. One of the points we made is that a lot of this stuff doesn't even deal with electronic media coverage. It's referring to statements made by public officials before the proceedings even began. So the defense's position that they had to include these things, we would push back against, because we don't think a lot of the things cited are even relevant to the actually narrow question that is before the court about whether electronic media coverage should continue.
And then I have like
Because
10
those
more out there.
statements aren't even really connected to electronic media coverage. They're connected to things that public officials said or did before the proceedings began. And we don't have a dog in that fight. We're not trying to litigate whether or not that was lawful or not. We're just trying to litigate, should electronic media coverage continue? And so the defense really didn't need to include, we argue, a lot of the things they did include that, again, are public statements that the public has a right to see and have access to, and in fact already has access to. So there is no reason to exclude the public from seeing those things. And for that argument in particular, I would again refer the court to Al Geyer, where the court talked about that very specific point, saying if the information is already in the public, then there's not anything the court can do by trying to restrict that information. Again, the best tools available to the court are the time-honored things that the court can control. The court cannot control public discourse, but it can control the jury that is actually seated and ensure that that is a fair and impartial jury. And so that is the best.
Kristen, do you see what Nikki just said?
Are there any questions Your Honor had on that motion?
No, thank you.
Yep. And before I sit down, I also wanted to add, I am prepared to address standing. I didn't know if that was something you wanted to hear from the news media today, but I am prepared to address that if you would like.
Right now, no, thank you. Mr. Judd.
Mr. Judd.
Thank you. Thank you, Your Honor. As Ms. Uresk suggested, I'm going to address briefly the motion to close the April 17th hearing in part. The docket numbers for the briefing on that are docket number 425. That's the defense's opening.
Has she used it?
Docket 448. That's the state's response. And docket 451. That's the media's opposition. Ms. Visser at the outset said something that I'm sympathetic with. I know the court has a lot of briefing before it on these motions. And she mentioned that it felt like we were drowning
For
in
you.
a First Amendment briefing. I don't think anyone wants to drown, but if I had to drown in something, I think I would drown in First Amendment briefing. Sounds delightful. The court ultimately needs to make a practical decision about each of these motions in front of it. And that's a tough task. And I want to help the court with that the best that I can. If the court is going to close or seal anything, the court has to make findings, and the court has to explain which interests it's weighing. It also has to do an important thing in determining that the restriction it's imposing on public access is the narrowest possible way of protecting the countervailing interests in favor of secrecy. So that's tough. The court's been through that several times already, including with the motion to disqualify and the hearing there. How do we identify an interest that we may believe justifies an exception from this rule that the public gets access to these proceedings? And then how do I make that as narrow as possible to ensure that if that interest needs to be protected, I am, but it's narrow. I'm grateful, therefore, that the defense, got this motion on file in time for us to discuss it today so that we can talk about that April 17th hearing today in advance. And I'm also grateful that that motion and both oppositions recognize what I think has to be the case, which is most of that hearing, if not all of it, needs to be open. The two sides have talked about the kinds of hearings that are presumptively open. This is one of those. There's no reason that it shouldn't be. It's not a juvenile matter. It's not another type of sensitive matter that would qualify, and any argument to the contrary has been waived. So we start with the presumption that this is open. The defense also recognizes, I think, that most of it should be anyway, that the things that they seek to protect are some narrow categories of information. I think where we run into challenges is a lack of specificity. And if we can't get to the specifics, justifying what exactly would need to be closed and why, then the presumption wins and it stays open. I see in the motion an argument that something about what they call a litany of potentially prejudicial statements may not want to be introduced. But of course, for the court to enter a ruling saying, okay, that part of the hearing will be closed, we have nowhere near the kind of specificity we would need to say what that would even look like. Would there be some sort of short colloquy where certain pieces of evidence would be introduced? If so, what? A certain statement by a public official, a certain news clip, a certain statement? We don't know, because the motion that will be discussed at the April 17th hearing is 185 pages long, and it has, again, a litany of information. It's possible that there may be some part of some piece of evidence in that weighty motion that the court may be better to review in camera, right? So as to not publicize it again and risk this republication problem. But we don't know what that is at this point. Another suggestion is that the December 11th closed portion may be discussed there. I think that's gone. We now have a transcript that has almost all of that hearing open. The last is that there may be some kind of private and personal information. Sorry, there's two more. There may be some sort of private personal information, potentially for a witness. The court has, very narrowly in the past, in this case, identified one instance where keeping at least one bit of identifying information off camera may be appropriate. Maybe the court would see fit to do so again here, but we don't know what the ask is. And at this point saying, okay, I will grant the motion to close a portion of that hearing to the extent that it implicates some kind of private information would be impossible for the court to do, because the court can't do that balancing test that the rule requires without that type of clarity. The last piece is alleged violations of the decorum order. Again, I struggle a little bit to understand exactly what would be presented that would justify closure. I think discussing, hey, we believe in these cases and these types of media coverage, there was something that was a violation. Something was shown that shouldn't have been, and here's the problem that it creates. Again, if we want to show the media clip in which that decorum order violation was broadcast, I think that wouldn't justify or necessitate closing the hearing. The court could look at it on its screen.
I didn't
The
say when it
defense would refer
ends.
to what we're going to show you right now is the following kind of violation. In short, I think the task that's been put in front of the court to attempt to close part of that hearing right now is impossible. What would the court say, I am going to close at this point, when everybody decides that the vast majority of that hearing needs to be open? It may be possible when we get to that April 17th hearing that the court may be faced with a request to say, here's what we're going to present. We're going to put this witness up, and this witness is going to talk about this thing. And it may have a more complete ability to
Bye,
rule on that
whoopsies.
specific issue then. But as of right now, I think not only should most of that hearing stay open, which everyone has agreed to here, but in the media's view, everything should. The last thing that I want to mention is the unique feature, the unique nature.
I use this in Ohio.
There's all kinds of different hearings, and they may, preliminary hearings, evidentiary hearings, the trial itself, those all may have different standards. What's unique about this hearing, of course, is that this motion asks the court to turn off cameras, to mute the microphone,
Hi, Zach.
and to no longer let the public be the kind of participant in this hearing that it has, in this proceeding that it has been to date. Saying, not only should the cameras be turned off, not only should the microphones be turned off, but the argument as to why that should happen should be sealed from the public, and the public kept out of that hearing strikes me as the exact opposite of what the presumption of public access is meant to do.
Yeah.
Of all the types of things that the public should be able to see argued, a question as to whether or not the public will be able to continue to observe the proceedings in the case seems like close to the highest potential instance in which public access should be granted in that case. We think this hearing should be open. The parties are taking all the measures that they can, and I know we have hard work from our people here representing the media and the public to try to abide by the court's decorum order. The court has done heavy lifting so far to initiate and refine that decorum order to balance the interests. We believe that that is the approach the court should continue to take, to continue to allow access, but to have appropriate restrictions to balance the interests. And we ask the court to do that with respect to the April 17th hearing as well.
Thank you, Mr. President. Defense, do you want to have a response?
Hey guys, please remember to hit that thumbs up button. Make sure you're subscribed and even
Just to
type a
Mr.
comment.
Ballard's
Thanks.
arguments, Your Honor.
Oh
We're not
no.
concerned with extrajudicial statements. That is not correct. The motion, and also responding to Mr. Judd's argument that we're not specific as to what it is we don't want publicized, that the motion sets forth 305 in great detail, the specific prejudicial pretrial publicity that we think prejudices Mr. Robinson's right to a fair trial. So it's hard to understand in light of the length of that motion and the
This
detail
guy.
at which the prejudicial publicity is set forth, how a media lawyer can stand before you and make a statement that we have no idea what they're asking to be excluded. What we're concerned about, as I indicated in the argument, is the specific categories of prejudicial information outlined in 305 that state opinions, extrajudicial opinions of public officials, extrajudicial opinions of the prosecutors, of law enforcement authorities. So when Mr. Ballard said we aren't concerned with extrajudicial statements, we are concerned with that. And those extrajudicial statements are outlined in the motion itself very
Don't bite me.
specifically. So the court has in front of it. And if the court, if it would assist the court, we could proffer to the court a proposed redacted motion, which would take out everything identified in that motion as prejudicial pretrial publicity. I think it's obvious from the face of the motion what that information is, but if it would assist the media in understanding exactly what we're talking about, we're more than happy to do that. And if that would assist the court. the idea that one of the media lawyers said, oh, the statements of the of public officials are not connected with the media. I can't understand, for the life of me, understand what that means. The media publicizes those statements. And if the court looks at all of the electronic media coverage that we've got outlined in the motion, the court will see it's a very slanted, biased rendition of the prosecution's version that Mr. Robinson is guilty and should be sentenced to death. There's no impartial reporting in any of the electronic media. So when the media lawyer says this coverage is, they're just public officials, we have no control over them, we're not in any way responsible for what they say or what they don't say, that is false. They are responsible in the sense that they are putting in front of the public a distorted view of an incriminating portrayal of Mr. Robinson. And that theme of incrimination is repeated over and over in virtually every one of the clips that we provided to the court. And we've emphasized that those clips are merely the tip of the iceberg. And we will present during the hearing much more than what's presented in the motion to prove that very point. And so there is a connection. And it's not only the electronic media, but the social media who is taking this information and spinning these theories of incrimination. Mr. Ballard says, oh, well, it's not, we haven't told the whole picture because some of that is pro-defense, and he indicates in his pleading that they're going to put in at the hearing publicity concerning conspiracy theories that are out there. And the implication is that those conspiracy theories somehow help Mr. Robinson. But we're on the side here of using this trial as a method to find truth. We have no interest in advocating conspiracy theories, whether they help Mr. Robinson or not. So I think it'd be helpful for the court to see some of these conspiracy theories. But the main point is the public is not being educated by electronic media. They're being biased by it, and they're being slanted to extreme views on both ends of the spectrum. And that's where the court, under the Maxwell case, says the trial court has a primary responsibility to step in and take measures that could lessen the impact of that publicity. The idea that it's already out there, and the Algier case, I want to focus for a minute on that case, because I think if anything, it supports the argument we're making. The court in that case was concerned with a letter from a jailhouse informant, a single letter, who claimed that Mr. Algier, I'm sure I'm mispronouncing his name, had confessed to him in a jailhouse conversation. And the trial court refused to seal the letter because there was already other publicity. We don't know what that other publicity is. It's not detailed in the Utah Supreme Court's opinion. But when the case reached the Utah Supreme Court, critical fact for the Supreme Court, was that in the briefing in front of the Supreme Court, Mr. Algier had included the letter that had been sealed by the trial court pending the appeal. He himself disclosed the content of that letter. And the Utah Supreme Court said, in affirming the decision of the district court that the interest favoring unsealing the letter outweigh the interest that favor keeping it sealed, we note that since the time of the district court's decision, most of the significant information contained in the letter had been introduced into the public arena. Specifically, in his brief in this court, which is a public document, Mr. Algier included the third district court's decision to unseal the letter. That decision, which was filed under seal, quoted the letter. Because these portions of the letter have been placed by Mr. Algier into the public arena and are therefore accessible to the media, any significant interest that would be protected by requiring the letter to remain
That's great
sealed
that it lets you
are
do
now
that.
greatly diminished. So how does that case compare to this one? Well, first of all, we're not dealing with information that the defense has voluntarily put into the public domain. in Algiers, there was no motion to file the letter under seal by Mr. Algiers. In this case, we filed all the relevant pleadings here with a request that they be classified as private. So counsel for the media misspeaks when they say, oh, well, once it's filed, it's in the public domain. The very purpose of the procedure to make something private is for the court to rule on whether it should be considered a public filing. So that procedure was followed here. It was not followed in Algiers. He put the documents into the public domain. The second thing is,
My heartburn.
I think strains credibility to say that the factual record in Algiers is in any way comparable to the
Coco,
extent
stop biting.
and nature of pretrial publicity in this case. We're not dealing with a confession letter by a jailhouse informant, a single letter by a jailhouse informant. You can't compare the president of the United States, the vice
Why is he
president, the governor,
bringing up
to a
the
jailhouse informant
president all the
in
time?
terms of the weight that the public is likely to give to that information. So the court in Algiers was not saying, we don't care what the pretrial publicity is. We're holding that in every case where there's been any disclosure of information, no matter what it is, that's the end of the ballgame, and the court has no obligation to try and restrict further prejudicial pretrial information. The court never said that.
Don't.
And when Mr. Ballard says he can't imagine any more prejudicial information
Welcome back.
than a letter from a jailhouse informant, I would recommend to him the facts of this case, because this is a case that goes way beyond a single letter from a jailhouse informant. It covers opinions by highly respected, in this county anyway, public officials who directly state that Mr. Robinson is guilty and deserves the death penalty. And Mr. Ballard says Rule 3.6 has no relevance here. It has relevance to the extent that it defines what prejudicial pretrial publicity is. It defines what the categories are. And the Levitt decision, which is cited in our motion by the recent decision by the Utah Supreme Court, emphasizes that the categories outlined in the commentary of Section 3.6 identify what those categories of prejudicial pretrial publicity are. And it's not, again, unlike Algiers, we're not talking about a single instance. We're talking about repeated exposure to the most prejudicial information that is imaginable. And what will come out of today's hearing will be more of the same. In other words, right now, as we're talking, there are media talking heads, law school professors, criminal defense lawyers who are being paid for their opinions and not disclosing that they're being paid for their opinions, who will say things like, oh, this motion by the defense is absolutely frivolous, or this motion is wrong, or this is why this motion should be denied by the court, or characterizing Mr. Robinson's demeanor, etc. So this case is not comparable in any way to Algiers, and the court should not buy into the notion that they are comparable. The idea that we're mixing the standards, I think, could be bounced back to their side, because they say, oh, the standard for closure of a hearing is compelling state interest and no reasonable alternatives. But they skip a step, which is this type of a hearing that we're seeking to close, the portions of which will discuss the prejudicial pretrial publicity. Is that subject to a First Amendment right of access? We haven't waived that argument. That's an argument that Kern says should be at the forefront of the court's analysis, regardless of which side is raising the issue. The court has to determine whether this hearing on the 17th is comparable to a trial or to a prelim. It's unique in the sense that it's focused solely on what everybody has to say is inadmissible evidence. Is that the type of procedure that there should be a compelling interest demonstrated? And in any event, we have demonstrated a compelling interest.
My
Mr.
dude.
Robinson's right to a fair trial by an impartial and representative jury. And that right, according to the U.S. Supreme Court, takes precedence over every other right.
Oh,
The
spinach.
press enterprise case that was cited about the efficacy of voir dire and the Algier case
Oh, Ralph.
that was cited for the same proposition conflicts.
Are you
with
English by
Gentile
chance?
versus Board of
Like from Britain?
the State Bar, which was decided years after Press Enterprise 2. Press Enterprise 2 is decided in 86. Gentile's decided in 91. And if you look in the discussion in Algier about what cases are cited, when the court talks about the efficacy of voir dire, Gentile is nowhere mentioned. So the Supreme Court may have its own view. The Utah Supreme Court may have its own views about the efficacy of voir dire, but I would ask, how does one explore with a
Fried
juror
bologna.
whether they have been exposed to publicity that is specifically prejudicial, things like a confession? Do you bring, well, did you see any, have you read it? You
Oh my
ask a
God,
juror,
sir.
Have you read or seen anything
Sorry,
in the electronic
Jesus.
media about this case? Not that I recall is a typical answer, even if they've seen a lot. And then the next question was, when you attempt, can you or should you attempt to jog their memory by mentioning specific prejudicial information? Well, how about a confession? How about a statement by the President of the United States that Mr. Robinson should be executed? Have you seen anything like that? Now, that type of voir dire is designed to bring to the jury's attention the very information you don't want them to have. So, just throwing out the vague proposition that, oh, voir dire, the traditional means of curing pretrial prejudice, doesn't deal with the realities of voir dire in a capital case where the prejudicial publicity is as extensive as this one. There is a discussion of
I really don't like broccoli at all.
this issue in an older case, but it always struck me as kind of really stating the truth of it. In the court, this is an old, high publicity murder case, California case, Corona versus Superior Court, 24 Calab 3rd, 872. And the court is characterizing its experience with voir dire as an effective method. And the court says, questioning on voir dire as to the effect of the media's
Thanks to
evidence and
whoever's
disclosures,
sending the
one
hearts.
prospective juror may deny or admit awareness. Another disclaim or admit prejudgment. One may falsely deny both knowledge and prejudice for the sake of a place on the jury. An honest juror may admit knowledge or tentative prejudgment and find himself excluded. Many will sincerely try to set aside their preconceptions and give assurances of impartiality, yet unconsciously bend to the influence of initial impressions gained from the news media.
I'd really like
And
to take a
along the
shower
same
before my
lines,
next stream.
we have in this case an expert declaration that
Thank you, Whoopsie. That really
discussed
helps.
in docket 305, which talks about the importance of repetition in causing conscious and unconscious bias in jurors. And the importance of unconscious bias is it's by definition bias that cannot be weeded out by voir dire because the juror doesn't know they've been affected by it. And the expert, this is page 94 of 305, says the volume of coverage in notorious cases can be overwhelming. And studies show that the quantity of pretrial publicity to which jurors are exposed affects their level of bias. Across studies extending back several decades, researchers have demonstrated that individuals exhibit a greater propensity to prejudge defendants.
He's
when
talking
they're
in
exposed
circles,
to more
for sure.
publicity, both as a general conclusion i.e. showing a general propensity to prejudgment based on an increase in the amount of exposure and in response to specific thresholds.
Coco, people are watching this. Coco, don't attack. I'm so sorry.
i.e. showing that prospective jurors exposed to at least 3 newspaper articles about a crime were more likely to believe there was ample evidence against the defendant. This effect has been demonstrated in both naturally occurring and controlled
Why are
settings,
you like this?
confirming the validity of the proposition. And along the same lines,
course
the
she
U.S.
just
Supreme
stopped.
Court, in a case cited on that same page, U.S. Department of Justice versus Reporters Committee for Freedom of the Press, 489 U.S. 749, says, the fact that an event is not wholly private does not mean that an individual has no interest in limiting disclosure or dissemination of that information. So the fact that there's already existing prejudicial pretrial publicity out there should not give rise to the conclusion that, oh, well, let's add some more. Because the court at this stage of the process still has the ability to control this process in a way that will protect Mr. Robinson's right to a fair and impartial jury by a representative jury. And just to say, well, we'll handle it down the road is to ignore the mandate of Maxwell that the court has to be
Oh my
proactive
God.
and to take action before the prejudice happens. So we're seeking to prevent future prejudice. It's already existing. There's no doubt about that. But to throw your hands up at this point, this early stage of the case, and say there's nothing I can do about it, we're just going to continue along the same lines, allow these people to keep making these prejudicial statements and hope for the best down the line, and that we won't have to exhaust the entire pool. We won't have to move for a change of venue. And again, there are costs associated with those remedies that we think argues in favor of this motion.
Thank you, Mr. Burt.
Thank you.
Oh, thank you.
All right, I just have a couple of questions for the parties. The intent
Be
is
careful,
to
Judge.
obtain these, and then the court will take a brief recess. I want to discuss, issue its ruling, and I want to update my notes. I've been taking notes the whole time. I'll be issuing a ruling, but I also, based off that ruling, will want to talk about what the expectation for the next hearing is, to set the guidelines in place so we all come in prepared, knowing what the expectation is and what we'll be handling specifically. All right, to the defense, most pretrial motions discuss evidence that has not yet been ruled admissible. If the court seals the January 9th motion simply because the evidence might be deemed inadmissible later, wouldn't that set a precedent requiring the court to seal almost all pretrial evidentiary filings?
I think it would depend
Long
on
sigh.
the nature of the evidence. In other words, if it's evidence that doesn't go to the heart of the case, court always has to consider the nature of the evidence.
Just like
Here
one
we're talking
sentence,
about
man.
essential forensic testing opinion evidence. And so that puts it into a category that I think is distinct from any and all motions having to do with any sort of evidence. There may be some evidence that doesn't fall into that category. And I note that on this precise issue the court raises, the sentence in Kern's tribute addresses that. The court says, if the prosecution elected to try to use such evidence in the preliminary hearing, in advance of a ruling on whether it should be suppressed, the defendant could seek special measures to avoid its public disclosure. So I read that as saying the court is not really focused on whether there has been a ruling on admissibility. It's, again, what is the nature of the evidence? Why are you trying to disclose it? And I think the court can make reasonable distinctions between, is this the kind of evidence that could cause problems, or is it, in the harmless error category?
Thank you, Mr. Burt.
Sure.
And in offering the opportunity, do the other parties wish to respond to that question? You don't have to, but if you want to, I certainly want to give you that opportunity.
No, Your Honor, thank you.
All right.
God bless you, sir.
All right.
Carissa, you're asked on behalf of the news media again.
Yeah, she's
So
sick.
just to respond to the sort of the test, the argument that the test should be whether the evidence goes to the heart of the case. That's not really a standard that I'm aware of in case law or the rules. Again, the court goes through the balancing test and there has to be, specific findings. There could be a substantial probability of prejudice. And here I would just argue that's just not the case. And I will just direct the court to the arguments we made in our sealed supplemental opposition that is very specific to this motion as to why that showing has not been made here.
Thank you. All right, to defense, you noted if full classification is denied, you would seek to file redacted versions. Have you prepared a proposed redacted version of these motions? And do you believe redacting the specific evidentiary exhibits and media links would sufficiently cure your constitutional concerns?
We haven't yet prepared those redactions, but it's easily done because it focuses on the factual portion of the motion. So essentially it would be submitted to the court, the legal arguments absent the factual basis that's discussed in the statement of facts and later referenced in regard to the criteria under the rule, some of the publicity set forth there as well. So it can be easily done. It would satisfy the concern insofar as the motion goes. What you would lose in that, I think, is at the hearing itself, having the court have the ability to actually listen to the evidence. I'm not sure. I think that falls into a different category. In other words, the motion is one thing.
Let me
but
go grab them.
presenting it live to the court, I think presents a different issue.
Watch out.
Perhaps that can be addressed by submitting to the court in camera the clips that are outlined in the motion, which that would satisfy our concern. But the only other thing I think could arise is if experts are commenting on something the court has considered in camera, those opinions might disclose that information. So that could be a special problem. But in general, I think redacting the motions and providing the court with a disk or a thumb drive that contained the clips with the understanding that that would not be disclosed. In other words, by providing that to the court, the media would say, oh, you provided to the court, therefore it's filed and we're entitled to it. I think the understanding we have to be the court is being provided this with the understanding it is private. And to answer the court's question, I think those kind of remedies would resolve the issue.
Thank you, Mr. Birch.
Sure.
All right, turning to the state, the defendant argues that publicly filing the motion to exclude forces them to republish prejudicial media links and private information protected by grandma, effectively doing the media's work for them. Does the state acknowledge any risk to the integrity of the proceedings by hosting a consolidated repository of this potential prejudicial material on the public docket?
I think, defendant, you can't ignore the fact that there is a risk that when you repeat something, it's emphasized. Certainly we agree with that there's a risk of that. I think Allgaier is controlling, though, where it says the fact that something is already public tends to support that should remain public, and that Allgaier, it didn't directly address whether that would risk republication, whether the republication would risk emphasizing, but certainly that's the undertone there in Allgaier. And I just wanted to clarify one point there. If you look at paragraph, just let me grab my computer.
Sure.
just go outside. I have to go grab him. He's gonna
If you look at paragraph 16 of
incite violence.
Allgaier, this is about the point that Mr. Burt made that defense counsel in Allgaier actually attached the letter to his public brief in the Supreme Court. That was not the decisive factor in Allgaier. All that did was give the court even greater confidence that affirming the district court's ruling to release the letter was correct. If you look at paragraph 16 in Allgaier, about halfway through the paragraph, it says, the district court considered the specific language within the Cobb letter. Cobb is the name of the inmate. The specific language within the Cobb letter and its potential impact on Mr. Allgaier's right to a fair trial. But the district court concluded that given the amount and type of prejudicial information already in the public domain at the time of its decision, unsealing the Cobb letter would not undermine Mr. Allgaier's right to a fair trial. So the district court's decision was based on what was already in the public, the information that was already public when the letter came before the court. The letter at that time was still sealed. And then the Supreme Court does not say, it doesn't question whether that balancing was correct or not. It says we are in affirming the decision of the district court. We note that the letter there's even more information of the same kind that was already contained in the letter because the letter itself was now attached to the brief. So the decision in Allgaier was based on the information that was already in the public domain, even absent the defendant attaching the letter to his brief.
All right, thank you. Court has no further questions. We are right at the noon hour. The court intends to take a 15-minute recess to review my notes, considering the arguments, and to issue a ruling on this case as it relates to what's before the court. And then we'll come back and discuss how we will address the April 17th hearing. Court is in a brief recess.
All right.
Okay, how long did they say they were going to break for? I hope someone was paying attention. I was trying to get everyone situated so that I could sit here without being bothered. 15 minutes. Perfect. All right. We are going to... Might as well keep the volume on just in case. What should I do? I kind of want to make that small. Here, we'll go like this. Because I can hear it. I'm sure you guys can hear it. We're just going to have to roll with this because this was not planned. So it just so happens that I have a crap ton of tickets on me. Okay. The ones that I do not finish during this break, I will do during a members only stream. Okay. So this is the cash word. And basically, I am going to mute this. Or turn it down. Okay. Get this out of the way. And we are going to want 3 words or more in order to have a winning ticket. Where is my quarter that I literally just had? Like I said, roll with it, guys. We're doing our best. Okay. So we are going to start with our bonus letters. First one is F. Can you guys see that? I'll leave that right here. So let me know where you guys see F's. I am relying on your eyes. I think that's it. That's a C. Scent / topic. Echo. M. Whatever word that is, I'm really like, oh, salami. Let me put on my glasses. Is that the only M? Why don't I, instead of going individually, which I prefer to do, why? I'm going to do a line at a time since we don't have much time. Wait, that wasn't a Y, that was an X. Oh no. Whoops. Axis. All right, so the next line is W, Q, Z, and O. A bunch of duds, in my opinion. O and W for O. So, wireless. I should, if anyone questions what we're doing, hopefully someone in chat will say that it's on break. Because if I put up a message on the screen, it's gonna make it so you guys can't read this. There's a lot of O's. Envoy, Echo, dog, wireless, polar, sold, O and own, sort, opinion, twice. I think that's it. So what about X? I don't recall seeing any. Oh, here. Trapeze. W in SWAT. Thank you. Or sway. Do we have any cues? No, no. Hold on. I really want to make it so people know that we're like, oh, that's good. That's good. Okay. W and own. Okay, where's own? I see onward. Oh, I see own. I see own. Okay. U, J, B, H. H in echo. U in thus. I'm looking for H's at this current moment. Disclaimer, please be 18 years old. Yeah, you and I, Josh, both got that around the same time. What about you? I don't know. I think that was a kind of a dud. Okay, so K R T A. A in east. T in thus. T in try. A trapeze. A and T in SWAT. T in sort. Hi, Nicole. A in spa. T in scent. Oh, shoot, I forgot about the people on their phones. Thank you for saying something. I'm sorry. K in sheepskin. T in east and last. A in trap, A in spot, A in eyeglass, A in last, A in onward. I know where the onward is. Trap. Salami. Last. Idea. Axis. A in polar. A in pirate. Where is pirate? A. Wait, that was a T, Lacey. Oh, well, I also needed a T. Okay. T in the bottom square. Yeah, scent. Oh, there's botany. T A O. Was there an N? So remember, there's no Y, but I thought X was a Y because problems. All right, there is a Y. Trying to make sure that the phone stream can still see, which they really can't. Okay. So for the bottom, for the phone screen, I'll just move this up right now so you guys can see YPDI. So onward, D. Trap, P. Oh, and there was a T. So trap. And an R. How did I miss this? Whatever. P and trap. Idea or topic. Okay, so 2. Coco, I don't think it's going to be a good idea for you to come sit on my lap during this part. I'm sorry, Coco Chanel. P in, okay. So now that we've gotten that, we are moving up to the top. But you guys can't see that very well. I don't know the setup for this. I need to figure out how I can do this. R. I missed a bunch of R's. Oh, so we have officially won because I have 3 matches. Didn't I get trapped? Or is that an old comment? D in idea. P in rip. I in rip. So we don't have any We have R. We don't have an E. We don't have an S. So echo and thus are out. So is east. Envoy. No. 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 P. Is there an L? No. Spa. There was a P. There was an R here. I hear noises, so I think maybe they are getting back to this.
Thank you for the patience of the parties. This court has considered the oral arguments made today and has considered the briefing which has been previously submitted. And I commend the parties for their diligence, their arguments, as well as the quality of briefing that was done on this issue. And so the court is going to issue its ruling on what is requested and what is before the court. Before the court are three motions.
Hi,
to
Cyberchick.
classify court records. Defendant's motion to classify as private motion filed January 9th with exhibits. Defendant's, which is docket 285. Defendant's motion to classify motion to exclude, docket 310. And defendant's motion to classify reply in support of motion to exclude, docket 400. The public has a presumptive right to access court records. Open court records assist in educating the public about the workings of government and the decisions being made on the public's behalf. Contribute to the informed debate, allow the public to hold public officers and employees accountable, increase public confidence, and provide material for independent research on improving government policy. The right of access, however, is not absolute, as cited to in Algier. Other factors may favor closure of the records, such as protecting personal privacy, non-parties participating in the court proceedings, and the defendant's right to a fair trial. A court may consider any relevant factor, interest, or policy in both in favor of and opposition to closure in determining whether to classify or close all or part of a court record. In making its determination, a court must make findings and conclusions about specific court records, identify and balance the interests favoring opening and closing the record, and if the record is ordered closed, determine that there are no reasonable alternatives to closure sufficient to protect the interests favoring closure. With this legal framework in mind, the court now turns to the pending motions to classify. And as it relates to defendant's motion to classify as private motion filed January 9th with exhibits docket 285. Defendant seeks to classify a motion filed on January 9th, 2026 as private because it addresses evidence that has not yet been found to be admissible, and it is of a nature that
person needs to leave.
Potential jurors. If the court denies his motion to classify, defendant requests an opportunity to file a public version of the motion that redacts the attached exhibits and details from the exhibit discussed in the motion. Defendant does not provide any specificity explaining why the potential evidence discussed in the underlying motion is of such nature that its disclosure will taint the jury pool. The potential evidence discussed in the motion is technical and discusses the process of scientific and
person in there?
physical evidence. It does not contain any obvious private or inflammatory information. While the evidence has not been admitted at trial, there is no pending motion to exclude it. In balance, defendant has not provided a sufficient basis for the court to find that the interests favoring closure outweigh the interests favoring an open proceeding and the presumptive right to access. Moreover, as the Utah Supreme Court recognized, even in highly publicized cases, the defendant's right to a fair trial can be protected through the regular, time-honored process for selecting jurors, like enlarging the veneer of potential jurors.
You just tell us what
revising
you're
a detailed
gonna do.
juror questionnaire, and conducting a thorough voir dire of potential jurors. Defendant's request to classify the motion filed on January 9th, 2026 is respectfully denied. As it relates to the motion to classify motion to exclude, docket 310, defendant seeks to classify his motion to exclude cameras from the courtroom because the motion compiles a litany of unfairly prejudicial and oftentimes inaccurate electronic media interviews, comments, and photographs. Furthermore, the motion references court filings that are classified as private and references the publication. of
He's gonna say
information
that
of individuals
media is allowed.
involved in this case, allegedly in violation of law. Defendant does not provide any citations to the underlying motion to aid the court. in
Thank God.
identifying the potentially private information. The court is sensitive to the amount of pretrial publicity generated by this case, including an extensive amount of public commentary and inaccurate or conspiratorial descriptions of alleged evidence supporting or negating defendant's guilt. A substantial amount of this pretrial publicity is organized and memorialized into defendant's motion. Because the references to pretrial publicity are, by their very nature, already contained in the public arena, interests favoring closure are greatly diminished. In this citing to State v. Algier, the public already has access to the majority of the information contained in the motion. Upon balancing the interests at play, the court determines that defendant has not shown that the interests favoring closure outweigh the interests favoring access to the record. With the exception of the potentially private information referenced in the motion to classify, the court orders defendant to file a version of his motion to exclude cameras, referencing docket 305, that redacts private information referenced but not specifically cited in his motion to classify. The redacted versions of the motion to exclude cameras must be filed with the court by the end of business on March 30th, 2026. If no redacted motion is filed by that time, the court will reclassify docket 305 as public. If a redacted motion is filed, the court will maintain the private classification on docket 305. Accordingly, defendant's motion is granted in part and denied in part. Finally, turning to the defendant's motion to classify reply, docket 400. Defendant seeks to classify as private his reply memorandum in support of his motion to exclude cameras from the courtroom. Defendant argues that his reply memorandum should be private because it references portions of the motion to exclude cameras, which he has also moved to classify as discussed in the ruling on docket 310. Defendant does not cite any part of the reply memorandum that references potentially prejudicial information in the motion to exclude. Based on the record before it, the court concludes that defendant has not provided a sufficient basis.
What do you know?
The court to find the interest
Mr.
favoring closure
Has lost
outweigh interest favoring
another bunch of
access
motions.
to the reply memorandum. As such, defendant's motion is respectfully denied. I will go ahead and sign this order and it will go into the record. With this in mind, counsel, how would we like to proceed? What I want to turn to next is this upcoming April 17th hearing, how it will be conducted, and
Do not
so
write
we
me.
all have a good idea of what to expect and to prepare for. And so first, I'll hear from defense in regards to your expectations on moving forward, given the ruling of this court, and then I'll turn to the state as well. All right. Mr. Burt.
So, Your Honor, we anticipate calling several witnesses. One witness would be in the nature of a foundational witness who would summarize for the court the nature and extent of the publicity. Would be testifying to certain things like publication, scope, number of times certain articles have been referenced. We would be playing for the court the various clips that are referenced in the motion as well as others not referenced to provide the court with an overview of what we think the court needs to look at in terms of the nature and extent of the publicity. Then we would also be producing a expert witness whose declaration has already been provided to the court and to the parties. And that expert would testify to the facts and opinions outlined in the declaration that is attached to document number 305. We'd also have a third witness potentially who would be testifying to laying a foundation and testifying about a public opinion survey that is in progress right now. And that would be the extent of our evidence.
All right, thank you, Mr. Burt.
Sure.
To the state.
Thank you, Your Honor. Chad Grunander for the state. I would anticipate that the state would be calling one witness, and it would be in the nature of a foundational witness to just talk about the nature and the extent of publicity that is negative towards the prosecution and or negative toward Mrs. Kirk. And I believe that would be the extent of the evidence that would be presented from the state's side.
Thank you. All right, any other input from other parties?
Your Honor, the media does intend to be there, but we don't intend to try to complicate matters. We'll be there to make argument as would be helpful to the court and to protect the interests that media believes may not be addressed in the other argument, but we will sit on the side table there as well.
All right, thank you. Thank you to all parties. I appreciate that information. Given the detailed motion filed January 9th, the court will read and prepare as it already has for that. And so the court finds it unnecessary to present all that evidence verbatim. The court does not need to see the video clips. And if defense wishes to give summaries of what's in the motion, the court allowed the overlinked memo to be filed with the intent of allowing you that ability to put in detail what you want to be considered and include your argument. And so the court accepts that and receives that and will review it thoroughly. But for the benefit of this hearing coming up, the court does not feel it is necessary to replay what is listed in the motion. Again,
Yeah, I won
if you wish to give
$5.
Summaries of that, I understand that's going to your argument, but to go through it all again as detailed in the memorandum is not necessary for the finder of fact, the court. And so I will, that is one of the guidances I wish to give. In regards to the witnesses, that is fine. What I would ask is that your witnesses be succinct, on point, and let's stay focused on the issues that are before us. My fear is that we start veering in other areas that are not germane to the issue. That's
yeah.
And this goes for both parties. I'm looking at Mr. Burt, but I equally am
Mr. Burt, who
considering
won't.
the state as well, because you indicated you're calling a witness. And so I ask that you prepare that witness to stay on point and to focus on the main issues that is before this court. We are scheduled, I believe it is April 17th at 10 a.m. And so we do have the remainder of the day. That being said, just because it's there doesn't mean it needs to be used. I want us to be focused in addressing. I also wish to encourage the parties to give your argument the weight that it deserves. This is an important issue, and I encourage both parties
Hey,
to be
Coco.
fully prepared and argue it. This is an important issue. We recognize it for both Mr. Robinson, for the state, for victim
Stop.
representatives,
Don't
and
bite.
for the issues of open and transparent courts. So the court is prepared and will be prepared at that hearing to hear the arguments. And I anticipate, unlike today, I will not be issuing a ruling on that day. I believe that what will be argued, the court needs to let it percolate, to examine, re-examine the motions, examine the notes to ensure that the ruling the court makes properly balances the constitutional rights of Mr. Robinson, Ms. Kirk, and the concepts of open and transparent courts. With that in mind, counsel, is there any other issues that we need to address? Mr. Burt.
Two questions. We had anticipated filing with the court either a disk or a thumb drive that contained all the reference electronic media cited in the motion. I assume from what the court said, the court has no objection to that.
No. And, well, to the state, any input on this request from defense? All right. Mr. Grunander is submitting on it. So I'll accept that and I'll receive that to review just to ensure, because sometimes URLs change. And so I appreciate you providing that so the court has a single place to refer to.
Sure. The second issue, Your Honor, I came across when I was preparing for the hearing today, a letter brief that is online dated October 28th, 2025 from a group called Human Events. And it's addressed to Your Honor, and it's in the nature of a brief on the closure issues we've been discussing today. It indicates at the bottom that it was CC'd to the parties, but discussing with the prosecution, neither party has actually received this. I was curious as to how the court handles, if it does, letters of this nature where people are, unbeknownst to the parties, providing opinions, and in this case, legal briefs to the court, which I assume the court is not looking at, but I wondered we don't see this filed in the docket.
Right. So that would be ex parte communications.
Right.
And the court has not reviewed that. Do we
Sorry.
have a record of that? What is the request of the parties we have a record of it. I haven't
Has
reviewed
she
it.
been
It wasn't
weaned?
proper for me to do so,
does
so
that
I have
mean?
not. What is your request as it relates to that particular? brief?
As long as that's the court's ruling, that was our concern.
Okay.
And just to make clear that in fact is the rule is.
I had to
is what
send
we
out
are after.
a message.
I
Thank you.
appreciate you addressing that.
Sure.
To the state, any final issues?
The defense.
There has been discussion today about the status of the April 17th
Hi.
hearing itself, whether it will be open or closed or portions of it. I'm assuming that that'll be addressed first thing on April 17th.
It will. I wanted to see if the defense wishes to file that motion in private. That
This is like a weekly thing for me.
And I'll take it from there to see if there is private personal information that is anticipated being argued. And so I want to make sure that that's fully vetted out, the parties see, and that we can prepare. I don't want to simply say it is.
She's like 10 years
The
old.
presumption is it will be open, but could there be a portion that's closed? Absolutely. I just don't want to state how much or how long, because I don't know what the depth of that information. So I want to review that, but the anticipation is it will be an open hearing.
I know what you're
There is a
referring to.
portion that dictates that closure is appropriate after balancing all the factors, then there will be a closed portion. Thank you,
Understood.
Mr. Commander.
Thank you, Judge. And then lastly, Mr. Novak did forecast a motion with respect to the preliminary hearing. So we're going to discuss that further today. So.
That's right, Mr. Novak. You talked about that.
The message I sent out was about catching strays.
At this point, what I anticipate is let's go ahead and brief that so it's fully briefed. Right now, it seems a bit premature because I'm not sure when that information is going to be passed over to the other side, how that affects how it's processed and reviewed. And so I'm happy to set a briefing schedule. It sounds like both parties are aware that the scope of what discovery could be coming over, but may not know all the details because it hasn't been passed over. Mr. Novak.
So that's fine. We're happy to brief it, and I think we should, in the time permitting, set a schedule so that
Absolutely.
the court can rule on that before its schedule gets worse. What counsel for the state told us yesterday is that they
I
have
was
2 requests for
joking
materials
that
in
she
their
was under
application.
my blanket
We
breastfeeding.
also received yesterday,
Yeah.
separate from the
It was
forensic
a joke.
sciences, a hard drive that has the images of all of the seized devices, at least one piece of evidence that I think that the state wants to present at the prelim is somewhere in one of those devices in theory. The state may have another way to present some of that evidence, but we don't know yet. So that's like an additional piece of that. And we, of course, haven't opened that box. We haven't sent it to the right expert. We do know that once we get all of the ATF case file materials from their forensic work and the ATF and FBI data files that we don't have from their forensic work, that it's not just about counsel receiving this, obviously, Your Honor. There's nothing that we can do, for example, with proprietary scientific data that has to be run through software that our experts have access to. So it's not like, oh, we got some information, we're ready to go. That's just what I if I didn't adequately express that this morning, I wanted to do that. So we can brief it. It sounds like
It's just like so boring to listen
we should
to.
start with Mr. Robinson's motion to continue.
Like
I guess the
Bueller.
question is, working backwards, when does the court want to hear that motion?
Well, I certainly want to address it before
Nobody.
the preliminary hearing itself, right?
Sure.
That would be appropriate. Well,
How long has
quickly,
this
if
been
you have that
going on?
motion filed, I guess that gets the train on the track.
I think it could be fully briefed if everybody is cooperative about that, so that it's ready for submission before April 17th.
All right.
Okay.
All right. So
I mean,
it's-
that's basically a month and a couple days to brief a important but discrete issue.
Of course. And so is that, how much time would the state need to respond? All right. So the 24th of April, that would be the preceding Friday.
All right, let me write that down.
So
I was suggesting, if I may, that we would fully brief it so that when we are here in person with Your Honor on April 17th, the court can hear argument if necessary and issue a ruling.
so are you saying your motion as well as the other side, or what's, I want to make sure.
Yeah,
I
I'm
understand.
saying that we can file our motion. Let's just say we need 10 days from now, or maybe
Okay, I see.
2 weeks to file the motion. And the state saying they have a week, maybe we have a few days for a reply as necessary, and it's submitted sufficiently in advance of April 17th, since we'll be here on that day, for the court to actually hold a hearing on the motion
Yeah.
to continue.
Let's like
I see.
kill
what you're
two birds with one stone, man.
saying. So just for clarity.
It makes sense.
You'll have your motion filed within 2 weeks, which is March 27th. And then state can have its reply by April 10th. And I think that's what Mr. McBride was alluding to. And then on that April 17th, the court will be prepared to hear argument on that as well.
I think Mr. McBride said they need a week. We want to file a reply, although we won't.
Hey,
be able
Ashley.
To do a reply.
Okay, so I see. So from the 10th to the 17th, if you wish to file your reply of April. Okay. And then by the 10th.
Definitely.
All right,
So it's the 27th, the 3rd, and the 10th.
that's correct.
Bye, Kimberly. Have a great
Appreciate the
night.
parties working together to flesh that out, to address that. And then so as it relates to the April 17th hearing, that will be an additional issue that we address as well. And we do have the benefit of the day, so we can proceed accordingly. Anything further?
No.
All right, and to
You're so
defense,
welcome.
I'm anticipating Mr. Robinson will be here in person for that hearing.
Definitely.
Oh, is he not there today?
All right, counsel, I appreciate your hard work today and your arguments, and we have a good path moving forward, and we'll address the issues on April 17th, and I'll look for those briefing on the 27th of March, 3rd of April, and 10th of April as well.
Baller.
With that in mind, court is now in recess.
Okay, so that gave me approximately what, 15 minutes to until the next hearing starts. Guys, like, for my regulars, I know, like, Willa for you, he came on. I didn't see his message until later, because catching strays every day. I normally, if you're not a regular around here, I normally do a Tuesday through Friday stream beginning between 3:30 and 4:30. I've been testing different times recently, so it's important to turn on the notifications, like where the subscribe button is. You press the bell and then select all instead of the personalized. That way you are notified when I do go live. But with that being said, my regulars are like, what in the world? Why is Lacey on so early? I have covered, from what I know, every single Tyler Robinson hearing, because this is something that a lot of people care about, but just the line of work that I was in for so long, this is especially important to me. And so I'm glad that we were able to get this up and running within 10 minutes. I literally ended my virtual doctor's appointment, and I was like down here plugging everything in right as they were turning on the cameras. So basically what happened today is that the defense lost their motions to, I need to not read chat. Sorry, guys. Okay, I'm not reading chat. Defense lost their motions to kick out the media and to have a bunch of things not shown to the general public, essentially. That's like the highlight, very, very high level version of what happened. And I think we would have seen a lot of people going absolutely bonkers if the judge had not ruled that way. Like, real talk, people would have been fired up. And if you haven't done so already, please make sure that you have hit the thumbs up button and you are subscribed, because I'm less than 50 people away from hitting my next benchmark, which is 2,000 subscribers. And that's important to me. So I appreciate you guys doing that. And yes, thanks, Drifter. Have a great day. The defense attorney has been trying to kick out the media. Yeah, it's frustrating. And go figure, Nestor is part of this team. That is one of Kouri Richins' attorneys. And I'm still kind of aghast by what happened in court yesterday. The fact that the defense rested. It came in with all these grandiose promises of what it was going to show the jury when they put on their case to prove that a jury would not be able to convict her of all the counts beyond a reasonable doubt. And then they rested their case. Like, I don't care if you guys think she's an awful person. Respectfully, what were those attorneys thinking? I'm not saying that Kouri had to get up and take the stand. Absolutely not. She's so unlikable. After what she did to her best friend, like, what in the world? And it's just like, it's nobody? You're not gonna try anything? You who literally failed on like every motion before this judge, you are going to try and get the jurors to somehow think she's not guilty based on objections and the state's witnesses and trying to plant seeds of doubt that were not even planted. I would say they were just thrown onto a field and hope and pray. Yeah. The look on her face was not understanding what they were doing. I think she had to have known, because, let's call a spade a spade. Do I think she is morally bankrupt, a bad businesswoman, has a horrible morally, her moral compass is doing calibrations. But I don't think she's dumb in this area, because she was into true crime before she was arrested and put in jail without bond. So I think that there's no way that she could have been in that situation yesterday and totally oblivious to what was going on in front of her. So I'm literally, why? Wild. It's just wild. And today's hearing is to address the charging documents, and just the state and the defense to go back and forth and fight it, which is just, can't you tell I'm so ready for this trial to be over so we can do a new one? But I am interested in watching, closing arguments. I am absolutely interested in knowing what in the world the defense is going to try to pull out of their ass to save themselves. I mean, it only takes one, right? It only takes one person. But I don't even think there is one person sitting on that jury, based on what we know, that is picking up what the defense is throwing down. Okay, I was just reading what y'all were talking about. Thank you for... I'm not going to stop the stream. That would be silly. I have 51 people on here. I just need to figure out... Yeah, that would be dumb. That would be done. That would be way too much work. I'm just going to go straight to the other hearing. Does anyone know, is this courthouse that Kouri Richins' trial is in the same courthouse where Tyler Robinson's hearing was just at? Anyone know? That would help me if someone could Google that besides me. I'm trying to pull up this, that, and everything else. Oh my gosh. Let me share this screen with you guys. See what I'm doing right now, guys? Look at this. Look at this. Look at this craziness. I liked it. I liked the video. So please do your friend Lacey a favor by also liking the stream. If our numbers drop too much, then I may jump off. You think it's two different courthouses? Okay. Interesting. Willa, you're talking about not Charlie, you're talking about Kouri. He said he thinks he's the only one that thinks she's innocent on this stream. And he's a regular watcher of this stream, and he always goes with the hot girls, he says. That they could never be convicted of doing such bad things. And every time, I don't know why, it just makes me laugh. What do you guys have planned this weekend? Let's get... Yeah, I think she's guilty too. Where did I put all my other scratchers? It is such a bloody mess over here. Whoever, works in this studio should really take some time to clean it up. I just got one out, but I don't know. That's another shot. Okay. I'll switch over my my polls. Oh, wait, no. I thought my poll was about Tyler Robinson, but turns out it's not. All right, Mitchell. Bye. Enjoy running those errands. Oh, wow, Whoopsie. That sounds fun. This week flew by. It was a busy week for me, so I haven't even given much thought about the weekend, to be entirely honest. Let me rename this stream. Okay. Lacey, for the record, the name of this stream was Live Tyler Robinson Hearing Happening Now Breaking Court Update. Okay, live. Kouri Richins. Kouri Richins trial update. And then breaking news. What? TGIF. Kouri Richins and Tyler Robinson. You know what? I am going to put get ready with me because I might throw on some lip product, but I hate to break it to you guys. My makeup right now is from last night. It's not going to let me. It's not going to let me change it. Son of a biscuit. Yeah, that's kind of the pace that we're going at right now. I'm wearing last night's makeup. I'm feeling a little sad, little anxious, little betrayed. A little old. So the numbers that we need are 6 and 26. And if you guys like this, like you're really enjoying this, I can't pay to like do this every stream. Feel free to send donations if you want to see this, but make sure to stay like towards scratchers because otherwise it's going towards my like medical bills. I hate to be boring, but okay, 29. 16. Oh man, they're like really tempting us here. Teasing us. Oh, well, thank you, Whoopsie. That's so nice of you. I thought that might be it. Do I have anyone else in here who is a lefty? 28. 4. 17. 23, 27. Oh, I got an entry. That's exciting. I hope I get on the show. Cash Explosion is so much fun in Columbus, or in Ohio. Let me put this in an area so it doesn't get thrown out. Okay, well, thank you, Willa, for you. I was like looking at this quarter. Look at this quarter. And I was like, who in the tarnation? Your aunt was on Cash Explosion? I'd love to be on Cash Explosion. Oh! Why are they doing that? We'll finish up this one and then 16, 6, 14. We need an 8 and a 29. 4, 23, 17, 26. Needed that on the last one. 12, 21, 2. And it would have just been a one-time bonus. Just making sure that my eyes weren't deceiving me. They be crazy over there. It's a lot of fun. I enjoy watching the restreams of Cash Explosion on YouTube. Okay. B and A. B and A. A and magnify. Oh shoot. I keep forgetting about the phones. I'm sorry, phone people. We are looking for B and A. Yawn. What in the world? Okay. What else? Era. Lava and tuna. Pawn. Radium. Stamp. Okay. E and F. Or there's a lot of E's. Primitive. Oven. I honestly think we're probably waiting for Nestor. Universe. Honey. Sesame. Nicely. Menu. Type. I think that's it. I didn't see any F's. J and O. Now. rotor, oven, dog. Yeah, there aren't usually people in the horizontal stream, except for a few people. So it's pretty lonely over there. Most people are in the chat with the phones, or all right. Y and C. Pencil. Well, that was not the word pencil. What? I'm not even going to go there. Y and honey. Is there even a word? Is pencil even on here? Where did that come from? Y and magnify? I'm hungry too. I was like, I just had to make sure that I hadn't muted or like paused the other stream. C and Y. T and H. Type. Rotor. Primitive. Honey. No. Q and L. If you are one of the people that just jumped in here, we are waiting for the charging conference to take place in the Kouri Richins trial. And while waiting, I had a bunch of tickets and thought I would scratch them, at least some of them, because I need to save some of them for members only. So the next couple of letters are D and S. Radium. And R would be great. Sesame. Stampede. Next letters are V and P. Lava. So that's a whole one. Pond. Universe. Primitive. Why and yawn? I missed that earlier. Let it be an R. No, I and you. Why are they running so late? Oh, bonus play. Try again. Yeah. I don't think that like ever works. Who's fighting? Alcohol. I am just so allergic to you. Wow. That's wild. Your dinner? So in a charging conference, basically it's my understanding is they are going to go over all of the things that are written down for the jury to take back with them and mark like if they believe the person is guilty or innocent. And then like this may or may not be on the charging papers, but like the decorum involved with coming up with a verdict and like, you know, don't let anyone, sorry. Oh, I don't think they're fighting. They're Mormon. They're like way too nice to each other. It's actually kind of exhausting how nice they are to each other. Hi, Pearl. Hi, Pearl. Oh, wow. We're only, math is hard. 40 people away from 2,000 subs. That's awesome. And I mean exhausting how nice they are because like sometimes it's difficult to read or like hear the inflection and the words that are being used and be like, where are they going with this? Is this a good thing? Is this a bad thing? Sorry, Coco jumped off of my little workstation. You just never know. Well, we're definitely getting the views, but I've also been live for what, like 4 hours now? I don't know. 3 hours. What in the world? Oh, it's moving. I saw it move. Someone probably just like bonked into it, getting into their seats. Wow, you were doing dishes that whole time? That's must have been a lot of dirty dishes. Oh. Oh yeah, I'm having an operation. I am one of which is absolutely this tracks with me because of my luck. I am having a surgery for a disease called MALS, MALS, and only like 1% of humans are diagnosed with MALS. And it's basically there's not enough blood getting from my heart to the rest of my organs. And I can't be physically active. I can't eat a lot. I'm in tremendous pain. It's oftentimes said that the pain feels like that of end stage pancreatic cancer. So it's just, it's a really difficult and not very well known about disease because not many people actually ever get diagnosed with it. And it takes several years to be diagnosed with. You receive a lot of misdiagnoses and it's a very frustrating process. And because of all of these factors, there are not many surgeons who are trained in the surgery to treat MALS. And to put it in perspective, I received an informal diagnosis in September of last year. No, August. And then my referral to see a surgeon in September. And I only was able to see the doctor this week. There are not many doctors in the world. They're all in America, but not very many of them. So they're usually cardiac surgeons because it has to deal with the aorta, or general surgeons who just happen to specialize in this. My doctor said my surgeon, he does about 4 of these operations a month. And he's the chief of surgery. Yeah, I knew you didn't like spaghetti. Spaghetti gives me heartburn. Oh, well, if my in-laws were coming, I would make them eat out of the Tupperware. My mom had a cruise. Oh, wow. It's very unusual to find someone who knows what I'm talking about. So that's interesting. There were a few surgeons. There was one in Connecticut who's very well known. There are a few in Chicago. And the guy in Cleveland who I'm going to is is, wow, what a small world. It's usually women, but men can get it. Oh, here we are. So anyways, I have to have surgery and I'm a mess about it. I had to meet with my general practitioner today about my anxiety. My anxiety is absolutely through the roof. You have a surprise for them. Where'd you go? Once he starts talking, I'm going to go grab my allergy medicine. Well, thank you so much. I am going to start like vlogging what my experience has been like thus far, which is I hope that it's helpful. By no means whatsoever is it meant to is it supposed to be like attention seeking? Cuz that's not the end game here. I personally have really struggled with this diagnosis because there's like little to no information out there. And so my hope is that by being vulnerable and sharing what I'm going through, I hope that it can help other people, especially when they're going through the process of getting all these stupid diagnostic tests to like eliminate all other possible things that could be wrong, because it just takes so long. Like I had to do a barium swallow. Basically, I had to eat radiation or nuclear eggs, and they did a bunch of like scans and saw how fast like the food went from my diaphragm into my stomach and like into my digestive tract. And I had to carry around a card for a couple days that said like if I set off any machines like TSA machines, it's because I had just had a barium swallow. So lame. Oh my gosh, that's great. Congratulations.
State of Utah versus
Congratulations.
Kouri Richins. Counsel for the state, Mr. Bloodworth and Mr. Burmester in the courtroom. In the courtroom is
Wow.
Ms. Nestor with defendant, Kouri Richins. Participating via WebEx are Ms. Lewis and Mr. Ramos. Let me just provide a little
Are they
context
too
for where
busy
we
to show
are
up?
at the moment. I have given an honest try to updating the previous proposed set of jury instructions to reflect some events that occurred during trial, to reflect some, though not all yet, of defendants' proposals received by the court this morning. I've also provided a working copy of a proposed verdict form. This will be an iterative process. We need to go page by page. I expect I'll need to take breaks from time to time to consider the substance of your arguments. Let's just take it one step at a time. Mr. Bloodworth, Mr. Burmester, anything general before we begin?
No, nothing
Okay.
general.
Ms. Nestor?
No, Your Honor.
All right. So may we go by page number, working off of the draft that the court just provided to counsel. Pages 1 through 14 are the opening instructions that the court gave prior to opening statements.
Right.
Yes.
Any objection to including those in the closing instructions, Mr. Burmester?
No.
Okay, Ms. Nestor?
You want to reread them?
No,
Oh,
I'll
good.
start reading at page 15.
Oh, great. Then
But
I have no objections to them going back.
recent appellate decisions have chastised district court judges for not including them in the final set. So.
No problem.
Okay, pages 15 through 23 are Muji second standard instructions without modification that were also part of the party's proposed instructions submitted prior to trial began. Take a moment. Take
No
a minute.
objection from the state.
No
Okay.
objection from the defense.
Okay. Ms. Nestor, pages 24 to 25 is the substance, I think, or is a Muji standard instruction regarding in custody informants. It would require maybe a little editing to remove some unneeded syntax.
Mhm.
Syntax.
So first, I need to hear from the state about whether they have a general objection. And second, we need to make this specific, if it were given, to the time periods that Ms. Lauber was actually in custody and the evidence regarding those periods, because she's not in custody during the time she's on the stand.
Right.
Your Honor, the state objects to this instruction because this is for a snitch. She's not a snitch. It's a different circumstance. Now, the defense has proposed an instruction.
Dang.
From the 10th Circuit,
Right.
Yes,
state, yeah,
Garcia
right.
instruction, which seems more nuanced for the circumstance that we're talking about. So if we have to have one, then that would be the one we would prefer, rather than this snitch instruction.
I looked at the case that is the genesis of this. That informant was in custody at the time of trial and came from jail to trial and from trial back to jail. And so I recognize that this case isn't that.
The other thing is, Your Honor, the witness credibility instruction number 20 from page 22 allows both parties to argue whatever they need to under this circumstance. I mean, the unique thing is there is the idea that she was given immunity, or the testimony about immunity, as well as foreclosure. So that all is great for argument, but I don't know that we need any special instruction, given that neither person
Is
was
that
in
Eric's
custody.
dad or her dad?
Ms. Nestor.
Your Honor, I think case law is really
Yeah.
clear that witnesses who are either granted immunity or are bargaining in a jail setting for their own freedom when they give information, which is the circumstance with Ms. Lauber, are a special category of witness. There are things that a jury can take into consideration that exceed what is contained in the normal witness credibility instruction. In this particular case, while I agree there may be some editing we need to do on the in custody informant, I think the importance of this is she was she was making a statement with the understanding that, that her freedom was contingent on it. And I think that this is an approved Muji instruction. I think I agree we should probably limit it. When I submitted it, I was thinking all her interviews, she was in custody. But I didn't think about the fact that
Agreed.
she's no longer in custody. I never really looked at this instruction that way. I always looked at it as of the time that they cut the deal. But I could be wrong about that. So I don't have an objection to adding dates that she was in custody
What
if that
is
is
she
of concern to the
wearing?
court. I do think she made it pretty clear when she was here she wasn't. So I think the jury knows she's not currently in custody, but I mean, it doesn't matter. I'm fine putting those dates in. But I think the immunity one should be given in addition to this because the immunity agreement also covers federal immunity, state immunity. I think we should get both. And we can just take out whatever on this in custody informant doesn't
It is
fit our
hideous.
facts. We can just jettison it. But we are asking for both.
Mr. Burmester.
Your Honor, a couple of things. First of all, if we're going to identify a witness by name, it should include all of them that come within the definition. So it's
Yeah, I
not
would
just
say more
Carl Glover, it
90s.
should be
Understood.
Crozier.
The periods during which Mr. Crozier was giving the interviews, he was in
Yes.
custody, correct?
Yes.
Okay.
In
Well,
fact,
one-
we saw
one-
an interview
yeah.
with him in custody, in
Right.
stripes.
Same with Carmen Lauber, right?
Yes.
Okay.
And once again, this instruction is designed for the situation where the snitch doesn't know anything about the facts of the case, wasn't a witness to anything. They just happened to be a cellie or something like that. And
So they didn't
that's
kill
what
someone
this was designed for. That
by
is
giving
not
them
the-
drugs.
This case, both of them were witnesses to the things they observed. There was discussion about immunity, and for that reason, we object to this snitch instruction. And if we have to have something, then maybe either add to
There's
the
something.
witness veracity instruction or something along the lines of Garcia mentioned before.
Yeah, that looks like a shirt from Family Matters.
Let me think about this for a moment. Mr. Burmester, putting this instruction aside for a moment, any objection to including the 10th Circuit form instruction from Garcia?
I think the
People
10th
started
Circuit
watching when I threw something.
instruction from
and yelled.
Garcia is fine, but I think it's duplicative if you're talking about the snitch instruction
Okay.
as well.
I understand.
Who are you?
And Ms. Nestor, I understand defendant's position to be the state should give both instructions properly edited.
Right. It is occurring to me, if the concern is, there is a federal instruction that we often use when we have what are called unindicted co-conspirators, that are people that were actually involved that then flip on whoever's didn't flip.
Provide helpful information.
Yes, sir.
Yeah.
I don't like that word snitch, but
Yeah.
that one may be
You don't
closer
do one.
to the facts of this case. I just than this one is. And I can pull that up really quickly.
I didn't throw that at
It's a 10th
Coco.
Circuit pattern instruction for unindicted co-conspirators.
I'll take a look at it during a break.
I'll submit it.
Okay. We'll come back to that.
Okay.
Okay. I've made some notes. We'll return to this issue at some point.
Oh, great. Can't wait.
Okay. Pages 26, 27, 28. Standard Muji second closing instructions. Any objection, Mr. Burmester?
No, Your Honor.
I'm sorry. Which page is Your Honor?
Oh man, we're gonna have to go
26,
super slow for
27,
you.
28.
I think you have the fact versus expert witness in here twice. I think you have it on page 32 as well.
That's entirely possible.
So I don't have an objection to it. I just think we need to only have it on once.
Yep, I will take it out of this position. I'll omit page 26, keep page 32.
Okay. All right. And then the presumption of innocence is fine. The reasonable doubt, I understand this is a Muji. I understand there's some litigation going on as we speak in other states and in this state. It has been at least touched on that the language that if that evidence that reasonable doubt is evidence which leaves you firmly convinced that the defendant is guilty of the crime charged. There is some real question if firmly convinced actually properly describes what reasonable doubt should be. I understand this particular instruction has been accepted by the Supreme Court, I think in case law and obviously in Muji. So I concede that but I would like to preserve that error because I'm not sure that's going to remain this way forever. And so we object to the language of firmly convinced as being not strong enough to describe what beyond a reasonable doubt is.
I can't believe I still have power.
I understand, and the record reflects that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged. The court notes that defendant's objection in argument is based on State versus Wall, 566 P3rd 833.
Tell me that shirt doesn't look like a shirt from Family Matters.
On balance and based upon the current weight of Utah Appellate Court authority, defendant's objection is respectfully overruled. Anything further on that, Mr. Burmester?
No, Your Honor.
Okay.
And then what was the last one you went through, Your Honor?
Well, then we go to page 29,
Right.
which is not a Muji
She's a defense
standard
attorney.
instruction, but is a copy and paste from the last paragraph of burden of proof from the opening instructions.
Yes.
I see no harm in giving it again. This is what you asked for, right,
Yes.
Ms. Nestor?
Yes. Thank you for doing that.
Mr. Burmester, any objections?
See?
No.
Told you guys. Looks like shirt from Family Matters.
Bear with me, folks. Let me just make sure my notes reflect.
I have a lot of
what we
crap
talked
to
about
clean up
so
after
far.
this stream.
Okay. That brings us to page 30.
No
Muji
objection.
standard instruction.
No objection.
Mr. Burmester.
No objection.
Okay. Page 31 is the court's effort at a 404B instruction. It uses the structure of the Muji second 404B instruction, inserts the case-specific language requested by defendant. Mr. Burmester.
Your Honor, if the court is inclined to give this instruction, we would ask that it include all of the 404B non-character purposes, not just motive. But
do you have any other non-character purposes for that evidence?
yes, Your Honor, like all but one or two of them, I think, can apply.
Oh, here comes
As I
death.
understand, the only reason,
In key
and when I instructed
form.
the jury in real time, the reason I gave them was motive. Was you weren't,
Well,
was it also go to
Can it go
preparation?
to identity, preparation,
I know
intent?
it can, but we tried the case. Is that why you admitted it?
Your Honor,
Sir, don't yell.
The answer is yes, and it's been throughout our briefing since, the entire motions in limine practice. We're
having a high wind day,
based on
and we've been
motive
getting like
and
60
plan,
mile per hour
preparation, and
winds.
identity. Those
It's
words are
wild. Can
always
you
lumped
hear it?
together in our
I
briefing.
know, and talismanically, but not necessarily with factual basis. And so help me out. If I'm going to tell them that they can consider them for those specifics, there's got to be a basis. Or we can say other purposes such as motive.
I'm so allergic to this cat.
The reason I'm coming back to this is I want to be as close to the instruction I gave them as real time as possible, which we litigated in real time. And I
And
didn't
she
say
loves
the
me.
talismanic words in real time. I said motive.
Yes, Your Honor, but I think the court said motive based on what the defense was
The wind is
requesting
crazy.
in the instruction. The state wasn't limiting the instruction at all.
May we say such as rather than all of those combined?
I'm sorry, could you just say it in a sentence?
Yeah, such as determining motive, preparation, plan, or identity. Or determining things such as motive, plan, preparation, or identity.
For the limited purpose of determining things such as the defendant's motive, plan. Okay.
Yeah.
Yes, sir.
Okay. Ms. Nestor.
Well, I think the court was right initially. I've never been under the impression identity was an issue in this case. I don't understand how any of these things would go to plan or preparation. I think the way it's written is correct. So I would object.
Certainly the first bullet point would go to preparation.
Oh wow,
and plan.
that poor woman
Plan.
sitting in front
Not
of the
so much
sister
preparation.
with the losing of the
I just would
hair.
like the record to reflect we object to it, Your Honor.
Okay, hold on a second. I'll just make a note of this. We'll come back to it.
I do not believe that you are a redhead. You cannot trick me, gypsy woman. No. Be gone.
Okay, 32, 33, 34, 35, 32 through 36 are Muji's second standard instructions.
Welcome,
No objection.
random people. Please make
Your
sure
Honor,
to
on
hit like
33,
on this
the
stream.
law enforcement officers, I think that should be plural.
You were
Many
probably
law
brought here
enforcement
because I
officers
was
testified.
screaming.
So I think we have it in the singular right
Feel
now.
free to stay.
Okay. You heard the testimony of law enforcement officers.
Yes.
Got it?
And then the rest, I don't have any objection to.
Got it. Will do. Okay, 37 versus page 38. 37 is the motive instruction that the parties proposed pre-trial. It talks about Kouri Richins' motives,
I'm a little crazy.
plural, which is a little fuzzy regarding the law. Here, there are two aggravating circumstances. One qualifies as a motive, the other qualifies as means. The motive would be an element to the extent it's the aggravating circumstance. The means is an element to the extent it's the aggravating circumstance. In the abstract, if the jury were to find unanimously regarding the means, but were not able to reach unanimous agreement regarding the motive, there'd still be a basis for a conviction. So the the court proposed the version on page 38.
I can't believe this. I literally cannot believe we're
Here. Can I clarify? I was with you up until the very end of what you said, but
Of course you were, Nestor.
I think the court's probably right. Are you saying that the only thing that requires the motive is the subsection 1 of the aggravated murder, which is committing homicide for pecuniary gain?
Well, so if we go to the elements instruction, we just
Right.
want to look at that together as an
Right.
example. So go to page, for example, page 41.
Right.
You could have 8
Yeah.
jurors that unanimously agree on elements 1, 2, 3, and then when it gets to 4, they're going to have to unanimously agree regarding one of
Power
the two
went out
at
for a
least.
second.
Correct.
Now, they could unanimously agree regarding 4B without ever agreeing regarding 4A and without ever agreeing that about a motive at all,
Right.
just regarding the act.
I think that's right.
And so the way the parties had written it beforehand did not contemplate that possibility.
I think you're right.
I'm just not convinced that motive is coextensive with intent. And I think the state is required to prove it was the intent of the defendant to cause the death for the purpose of.
Yeah, the difficulty here is the pecuniary gain is a why, not a how, and why is motive.
Right, that's right.
Well, motive might be my financial situation is so distraught, I'm going to commit this murder. Or I'm just so darn greedy, I just want more money, so I commit a murder. I think motive might be involved in both, but I have to prove that was the intent to do it, was to make the money, whether you had the motive, this underlying thing or not. I don't know.
I believe intent goes to intent to cause death.
That is among the things that the jury would have to find unanimously.
Right. The pecuniary gain is clearly motive. That is a motive that they've alleged. And I agree that I think subsection B does not require a motive because it doesn't matter why she's administering the lethal dose, just that she is administering the lethal dose. And I think we just missed that in the one we submitted. I think the court's right that motive only applies to 4A. And so it's tricky to explain this to a jury without a side-by-side analysis of the elements instruction.
Now, another option, right, is just to not give a motive instruction.
That would probably be the best. Except that,
Because then we don't have to get confused about whether the why is part of 4A versus 4B. We can just not instruct regarding motive.
I mean, I do believe the motive is there in the elements instruction, whether we explain whether it's a motive or don't explain whether it's a motive, they still have to prove this. So I'm okay with no motive instruction.
If we take the motive instruction out, it kind of frees everybody up to talk about what they really mean.
Right.
Without having to thread the needle of what's an element and what's not.
Let's do that, Your Honor.
Yes.
Okay. Any objection, Ms. Nestor, to omitting a motive instruction entirely? A separate motive instruction.
I think it's just utterly confusing. It's going to confuse the jury. I think we should take it out.
Understood. Pages 38 and 37 are omitted. Okay. Page 39 includes definitions. In fairness, I'm not sure I got them all, so we may have to add some more in here as we go.
Your Honor, I think we've removed the domestic violence recitation, so the cohabitant and direct definition isn't needed anymore.
Yeah, it was unclear to me. It was a sentence that I read regarding counts 1 and 2 as part of the reading of the information, but we can take it out and just proceed as if it doesn't matter. What's the state's position?
Your Honor, I
She
know
don't care
we
no
didn't
more. She
pull
going
it
to
as-
jail. She's getting locked
I guess
up
we pulled it by
forever.
agreement as an element of the offense, not as a sentencing enhancement.
Right.
So I think the status quo is the parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right. It goes to sentencing, not to
But
conviction.
don't we need the jury to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Yeah, I think that was part of this, the stipulation is that it is just a stipulation of finding.
Okay.
The court's going to be able to find that, Your Honor. They were cohabitants.
Well, I just need a waiver of Ms. Richins' right to jury determination on that, and I can make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We do not want the issue of domestic violence in any way to be considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we agreed we would not
I was
challenge
gonna
that they were
say.
cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that
Okay.
at sentencing.
May I put it in my language and to see if you're comfortable with it?
Yes, sir.
Ms. Richins has the right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue?
I love how Nestor just said blah 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 at sentencing. Like she already knows she's cooked. She knows her client's cooked. They're just, it's radical acceptance at this point.
To the court
She
for
is.
determination by the bench?
She is.
Okay. Ms. Richins, do you understand the rights you're giving up?
Yes.
Okay. Are you waiving those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Fine. It's
She doesn't even believe she's innocent,
On
Willa.
that basis, I'll remove any reference to cohabitant throughout the instructions. Agreed, Mr. Bloodworth?
Yes.
Or Mr. Robertson, sorry. Ms. Nestor, any objection?
No,
I
no.
commend your unwavering support, though.
Okay, is this, Fred, Mr. Burmester, is this definition of attempt
Yeah,
the same as yours
that was added by the
what does
court
it
before I
mean?
ever
before you
got a
did this?
chance to ask him to with it. It appears to be the same thing. So.
Okay.
More
Just one moment, Your Honor. Can I just compare something just very quickly on the
Yeah.
attempt?
We'll need to take a break, so put a pin in it if you want. And
It just will take me
Okay.
1 second.
So she asked for a moment. The judge was like, nah.
Okay.
And she's like, it'll
All
just
right,
take
so
me a
We can
second.
just toss this, right, Mr. Burmester?
He's
we
just
can
here
set
for
this up.
aesthetic
Okay.
purposes.
All right. No objection to the rest of the definitions instruction, Your Honor,
okay,
or to number 40, which comes after it.
thank you. Mr. Brimmer, is there any objection to page 40?
No.
All right.
No.
That brings us to pages 41 to 42. Element of criminal homicide, aggravated murder, count 1. It is italicized language that represents a addition or proposal
What is
by
this?
one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. I think you know where I'm going with this.
Are you
So
married at all?
there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone, thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it.
That never happens.
My concern is if the jury thinks that under that circumstance, it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So I don't know how to carve out. It's my reading of this statute and the information.
Is this your first week on the job,
In order to
Nestor?
convict Kouri Richins of aggravated murder, which is this count, they have to believe that she knowingly and intentionally caused his death. If a jury is confused about whether knowingly and intentionally causing someone's death means buying something you think is oxy, giving it to someone and it's actually fentanyl and they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Right.
So I acknowledge that you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your proposed language.
Right.
Assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right,
Under 765205.
right.
If, for example, a defendant in a murder case wanted to request a lesser included offense based on this factual theory, they would have a basis to do so because that lesser included exists.
Correct.
That's not the same as saying, though, the state has to disprove that alternative beyond a reasonable doubt. It's not an affirmative defense.
Right.
I agree with that.
So I don't think I have to include that language in the elements. The real question is whether you're asking for a lesser included, or I mean, you could certainly argue to the jury some
That's-
factual inference that,
Yeah.
listen,
Her?
there's an
Argue?
inference to be drawn here.
Do her
that
job? What?
She got this stuff
No.
formed because he wanted it.
Yeah.
You know, that line of reasoning or doubt.
So,
But I don't think the state has to affirmatively prove without a reasonable doubt that this isn't
Hey, everyone checking in.
assisted suicide.
Please hit
manslaughter.
the thumbs
So-
up button. Thank
I
you.
think that the state has to prove it was a surreptitious administration. And I don't know how, I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died. So I don't know how we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say. I just don't think that's aggravated murder. If she administers it by handing it to him and he says thanks and eats it, that's not
Bye.
aggravated murder.
Well,
Even
here, I'm going to create a very morbid and dark hypothetical.
This is
Oh,
all
let's
dark
go.
and dark stuff.
Imagine a healthcare provider
Right.
says to a patient, would you like some morphine to help with your pain? They say yes.
Always say yes.
And then pushes the plunger way too far intentionally.
Enjoy the ride.
I
I
think
think
that's
there's an
still
intent to
aggravated
commit. That's an intent to cause
to
death,
cause
though.
the death. Yep.
Right.
Oh, wow.
But
Those are
we've
big words
got-
for you, babe.
Witnesses of the state coming out talking about you can be fooled by these pills. I mean, they put that testimony
Yeah,
out,
but that's
right?
a different element, right? You're down on 4B. I mean, I'm down on 4B. Intent to cause is up on elements 1, 2, and 3. We're talking about the how, not the intent.
Critical
The
thinking.
intent as to the result is the top level. That's homicide. It's the aggravating circumstance that's 4B.
He took Sudafed, Willa.
Let me pause there.
Sudafed.
I'm carrying a lot of water here. Does the state see it the same way?
Yes.
Okay.
We're in the-
And Your Honor, this, from reading the tea leaves.
just
on
took
how
it in front of you
fact-hemming
guys.
Evidence in this argument, the state is concerned that in, the
Pseudoephedrine.
state is concerned that the defense will not be precise in arguing the intent in closing, right? The evidence has come in and
But
this
once again,
discussion here today.
You're a
suggested
commendable
that
man.
The defense is putting the intent on a specific drug to kill, and that's not where the intent lies here.
No, but would you acknowledge that if the defense were able to persuade the jury, for example, that Kouri Richins intended to give her husband a non-lethal dose of hydrocodone, that would be a permissible basis to argue that she is not guilty of aggravated murder?
That is a permissible basis to argue she's not guilty under the second.
for the record,
element
my
of
dog's looking at me
aggravated
like,
murder.
aren't you
Why
going to
not
stop
first,
this
second,
shit
third?
going
She
on
intended to cause
outside?
his death.
Like,
She intended to give
what
him
kind of enterprise are you running here, Ma?
Well, okay, second and third together,
Yeah.
you know, we split them up here sometimes. They're in the same sentence. It's really weird that we split them up.
Right.
But the second and third together,
Right.
sure, that is fine. But intent is not an element of 4B. Like in
Agreed. Oh, I agree.
I actually agree with that too. I was just trying to figure out how to deal with this. scenario and not have a jury. I guess we'll just focus on intent. in the
I'm gonna
argument.
grab it.
Yeah, it's intent to cause a death, intent to cause a result. That's where the intent lies. If you intend to cause the result by means of administering what you think is fentanyl and it turns out to be hydrocodone and it's deadly either way, doesn't matter. Or vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree with that.
I think we're all agreeing.
I agree with that.
Okay. Can we put 2 and 3 into one sentence?
We can. We typically don't, Utah, because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
So, I mean, this is the way the elements instructions under Mucci typically work.
Yeah.
It's confusing.
You can send a strongly worded letter to the Mucci committee, but I'm going to stick with this for now.
Yeah.
But we're going to strike. Let's just go down the page here. Mr. Burmester, did I cut you off there?
No, Your Honor.
Okay. We're going to strike the language without the knowledge or consent of Eric Richins because the court rules as a matter of law that that language does not represent an element of the crime or an affirmative defense that the state has to disprove beyond a reasonable doubt. Okay. Then we get to the extra italicized language of which I've provided two versions, one more elegant than the other, and the more elegant one isn't mine. But rather than have a separate instruction for jury unanimity, one offense in 2 ways, I thought we'd just include the operative language here. And all we need to do is expressly instruct the jury that there are multiple ways to find that this was committed beyond a reasonable doubt, but you've got to agree about which one of the 2 aggravating circumstances you believe the state has proven.
I like how you went from like all caps the last couple days and like exclamation points to not caps and question marks.
You're right, because I was going to say I thought we did this, but you're right. We put it in a separate.
You're funny.
instruction.
Don't
This
leave
is much
this
better.
channel,
Put it in the
please.
Instruction, I think.
Stick around.
With all, I mean, let's be clear. This was Melanie's idea.
Yay, Melanie.
Yeah.
Yeah.
So we're talking about the top.
So you've
been
got
brilliant. A and B,
you got
right?
2 options
Yeah.
here, right? You got the more wordy option before the or the more elegant version after the or.
I think the top one's clearer. Even though it's longer, it's clearer.
Oh, you're right. I'm sorry. We'll put reason instead of motive in there. Good catch. So, Ms. Nestor, if we were to see in the top version, instead of saying for the motive of pecuniary gain, may we say for the reason?
Yes.
Okay.
And I think you also have motive
In the very beginning.
in the first sentence.
Yep. The reason or means. You know, as
The
we do this, though,
reasonable
I'm kind of
Armenians?
leaning towards the second version.
Your Honor, the state does too. I also think we need to account in the second version for the possibility of finding both. I mean, you say at least one,
Right.
but there, I think the next line, and you must unanimously agree which circumstance, I think we parenthetically plural it.
You want to say which or both?
Yeah, something like
Okay.
that. The state has proven.
Yeah, we can do that. Do you want to say which circumstance or circumstances the state has proven?
Yes.
Yeah.
Or just put a S in a parentheses, like, so it could be either.
What's that? Yeah. We'll just say which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding
Okay.
the time I wasted on option 1. Okay, pause there for a minute. I'm just going to read it out loud. You tell me if it hits the ear correctly.
Okay.
To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt, and you must unanimously agree which circumstance or circumstances the state has proven.
Jess, are you still
If you
here?
find the defendant guilty of aggravated murder, you must determine, we'll get rid of that sentence. Got it, thank you. And we'll just we'll mark your decisions on the verdict form. Okay.
I don't remember the
Ms.
part
Nestor,
about
anything else there?
him doing
Just
anything
a
other
minute.
than
I'm
Red
getting a
Devil.
text. I just want to make sure I'm listening to my
in high
co-counsel
school.
here.
This is why Jess thought that
No, that's fine, Your Honor.
my cat
Okay.
is still a
I will
baby.
make similar changes to the elements of count 2. So we'll
My
get rid of the
blanket.
italicized language in element 4. We'll strike the inelegant option 1, and we'll get rid of the reference to
Do crime,
cohabitant.
do time.
And then we'll
Period.
add the or circumstances.
Okay.
Okay. With respect to the definitions of mental state, murder is one of the, or homicide is one of the rare crimes where it is a result-based crime, not a
Crazy guys.
intent or
In
action-based
attendance.
crime, right? Notwithstanding your best efforts, if you don't kill someone, you did not commit homicide. So the mental state definitions have to be specific to counts 1 and 2, and they are different, I think, than counts 3, 4, and 5. Is that the state's
Welcome.
view of it?
It's certainly
Please
with
join us.
regards to 1 and 2. One would think this is a super easy thing to
Dude,
figure
who
out.
are
if
you?
Something
Not.
is specific or general intent crime.
Yeah.
And I've struggled with it for 30 years. Maybe that indicates I'm stupid.
Where did
But,
you come from?
I have no objection to proceeding with the way the court is laid out.
Okay.
Right,
The
'cause
mental states definition on page 46.
right. I think initially the ones we submitted, Mr. Burmester had actually put it on the bottom of the counts, and it was, I like this better, separate.
I'm sorry, friend.
I don't know. I always question whether jurors ever understand this, but I think this is the best shot we have at getting it to them.
Yeah, in fairness, I should probably move mental state to find counts 3, 4, and 5 to after.
After you
The
give the
elements
elements instructions, I think
So-
that would be better.
But while we're there, Mr. Burmester, I understand you to say no objection to pages 45 or 46. Is that correct?
Correct.
Okay.
That was
So you're going
like
to move
2
what's
hours
on
ago.
page 46 behind the elements instructions for 3, 4, and 5.
Correct.
That's better, I think.
Okay. Any other objection?
Just 1 second, Your Honor. I think this is the same language we had. Yeah, no other objections to that.
Okay. All right. I have lots of questions regarding elements of
I think we all
3,
do,
4,
sir,
and 5.
Your Honor.
Yeah, so do I.
Man.
So I got to pull the information. We got to look at the statute. Bear with me for 1 moment.
You mean you don't have the statute memorized by like the word to word definition?
Melanie, I'm not ignoring you.
Yeah, he is, Melanie. He doesn't like you, Melanie.
All right, so let's focus on count 3 for a moment. It's insurance fraud, allegedly committed somewhere between January 29 and August 31.
You're so
It
welcome,
is charged
Holly.
under Utah Code 76.
Here's your charging.
6, 521
D.
2D, right?
Yes.
All right, so let's start with a couple of my mental state. Because the statute does not
We should talk
specify
about my
a
mental
mental
state.
state, it's intentionally, knowingly, or recklessly, correct?
Well, it says it specifically in Part D.
Oh, with the intent to deceive or
But it's
defraud.
a specific intent.
Oh, there we go. Yeah, so this is where it gets confusing because 2 says with intent to deceive or defraud, and then 2D says intentionally, knowingly, or recklessly devises a scheme. So different intents for different parts of the elements, right?
Yeah, okay.
Okay.
Yes.
Devises a scheme or artifice to obtain ... anything of value by means of false or fraudulent pretenses, representations. So 2 questions here. I don't see from an insurer anywhere in the statute.
Agreed.
May we strike that language?
Yes, from the state.
I mean, I don't want to add language in, so
Okay.
that's fine.
So we'll take that out. And then Ms. Nestor, in your submission this morning, you make reference to 2D's
Right. Let me pull that.
phrase, fees for professional services.
Right. So I read this statute differently than the state does. I think they're trying to shoehorn a crime that is a different crime under the statute. I think if you read the plain language of the statute, taking out fees changes the whole nature of what this crime is. I think this is actually not the proper crime that they meant to charge, but now that they've charged it, I think they have to do it as written.
Oh
Well,
my God.
Tell me why subsection 521 2D
No.
read as follows based upon its plain language.
Hold on, Your Honor, can you give me 1 second? I had to pull the
You know-
statute up on my screen.
No problem.
May the record show, if I'm ever in trouble, please make sure that Willa Freyu is in charge of my public relations. He will white knight and simp for me no matter what. If I did it, he'd be like, "No, you didn't, honey. No, you didn't. Stop talking so crazy."
Okay, I'm with you. Please continue.
All right, so 521 2.
He is
an actor commits
neurotic.
a fraudulent insurance act if the actor with intent to deceive or defraud does one of a number of things, but as relevant to this case, D, intentionally, knowingly, or recklessly devises or scheme or artifice to obtain 2 categories of things in the alternative: fees for professional services or anything of value, and then by certain means. Why doesn't it apply equally to 2 alternative categories of things?
I read that differently.
Okay.
Of course
And
you
this is the
do.
fun part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be like, to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part
That's it.
applies to, it should be read to obtain fees for professional services or anything of value. In other words, I'm trying to get someone to pay me as an insurance broker by making false representations about what I'm selling you. I'm selling you something that's junk. It's not what you think I'm selling you. So I'm either trying to get a fee or have you pay me for the actual product that I'm selling you. But by means of lying to you about what it is I'm doing for you. That is what I think this is. And that is not what anything to do with Ms. Richins. I think they liked that second half of that and pretended like the first half didn't exist. And that's how I read this crime.
Hey guys,
It's
have
a
you
crime.
hit the like
There are people
button?
that go, I've
Thumbs up
represented them.
and
They
subscribe.
go around and they sell junk. They sell a policy that doesn't cover anything, and they get either a fee from you.
Why do you
as a
look like you're gonna
broker,
vomit,
or they
Kouri?
get a commission, which from selling you, they get a commission of the junk product, and it's fraud. And that's what I think
Do you
they're
need a
talking about in
Zofran?
this crime. And I don't think it applies here. And I want the word fees in there because I think they picked the crime. They got to prove it as it's written. And they just deleted that word.
You do the
Well, they're not proceeding under that theory, but it's in the alternative. I have to acknowledge the comma
That's
and then
fair.
the word or. And I can't consider the word insurance in the title of the section. That's non-substantive. In fairness, I see that the word insurance appears in section 2, so I understand. I'm looking at the definitions though for the part and the definitions in 101.5, and they don't define insurance. And the legislature's got to call it something. They chose to call it this.
Let's call them up.
This seems analogous to the statute for communications fraud, which really is fraud. Like the communications and the communications fraud isn't doing much besides requiring that somebody communicate something by speech, writing, whatever. I too wrinkle my brow at the inclusion of the word insurance, but it seems just to be a label that the legislature has used. The substance of the statute on its face says what it says.
Effaced?
Are you aware of any reported decision limiting the scope of this statute?
I tried. I looked. I couldn't find this particular, because I just kept reading it over and over, and I'm like, this is what you charge brokers with. This is what you charge, scammers in the insurance industry with. That's this crime. And I object to taking any words out of it exactly as it's written, because I don't think they've proved this. And I actually think they charged the wrong crime. I don't think that applies to the next two, but I do think it applies to this one.
You'd acknowledge that even if we put it in, it'd be an or.
Well,
I didn't think of that.
that's how you read it. I mean, if you take out the words or anything of value,
No,
it doesn't
I
make
wouldn't
sense.
take those out.
No.
Yeah.
I'm saying for purposes of trying to understand it in context, right? So like the initial part of this says intentionally, knowingly, or recklessly devises a scheme or artifice to obtain fees for professional services, comma, or anything of value. And their reading of that is that or anything of value goes back to a scheme or artifice to obtain. But I don't think that's right. I think it goes to either for professional services as their broker or anything of value, like you made them buy a product from you. And so I think they should have to say exactly what it says on here, and the jury's going to just have to figure it out. But
Okay, but even in your world, in your view,
yes.
I hear you saying it would be 1, Kouri Richins; 2, with intent to deceive or defraud; 3, intentionally and knowingly or recklessly devised a scheme or artifice to obtain
Fees for professional services.
3A, fees for professional services, comma, or 3B,
But that's,
anything of
That's not-
value.
that's not how it's written, though, Your Honor.
It's exactly how it's written.
Oh
I
my
just put the
goodness.
comma and the or in the same place.
No, you put a B in there, an A and a B, and I think it's all connected. I don't think it's written that way.
Oh, okay. Well, then we should take the 1, 2, and 3 out as well.
Take the, which one?
Never mind. I understand your point.
yes.
Okay. Mr. Burmester, go ahead, sir.
If we're going to add the theory that we're not proceeding with, then it should be A and B to make it clear, because it is an alternative. It's a list of two.
Yeah.
It's,
I don't know how to read it any other way.
if that's wrong, it comes back though. 'cause
Spanish.
that's not- these go straight to
Taiwanese.
elements.
Okay. So,
Mongolian
Mr.
grill.
Burmester, any objection to including the language in the alternative form as it exists in the statute?
As long as it's A, alternatively A or B.
Okay.
I object to the A or B, Your Honor. I think it should be all one sentence, like exactly like it's written.
I understand your position. Okay. Let me give that some thought.
I thought about it. No.
Your Honor,
Moving on.
Mr. Ramos, go ahead.
just as you're giving it some thought, and I'm looking at 76-6521. Just
The
from
third
code.
Pepsi I've had to take
An actor
today.
commits a fraudulent insurance act. I just wanted, I had missed it on, Your Honor probably didn't miss it. I missed it on the first one, but going back to the insurance act, that isn't in the instructions as it currently is, but just highlight it now as Your Honor looks at that.
Okay. Thank you, sir.
Thank you.
All right. Very good. I've got
I
your
think
notes there.
he's the
Keep
only
going.
good thing about this team.
Regarding count 4, I didn't see any disagreement between the parties regarding the elements for count 4.
No disagreement, Your Honor.
Mr. Burmester.
Did we talk about element 4 of count 3? Because I'm not sure where that came from.
Oh,
Dear God, I hope
went
we
too
have.
fast. I don't understand where that came from either.
I'm sorry, what? I didn't understand what he said.
Paragraph 4 of the elements on count 3
Oh,
on
on
page
count 3.
47.
He sounds
I'm
like a
sorry,
man that lives in a
Just
booth.
1 minute. I thought we were on 4. Okay, element. Oh, took a substantial step. That came from case law. That's case law.
Have the citation.
I did
Yeah,
on the one that I
what-
filed. Let me pull that up, Your Honor. Just a moment.
What case? Like, please divulge the court.
It's document 1584
I do notice
On the
that I
docket.
tend to get a little
and
like "Woo," Kramer-esque towards the end of a trial. I've just had it.
this is a different one. Let me see. I might have written it in my notes to the state. Just a moment, Your Honor.
You know, the thought has crossed my mind because I'm trying to give grace. The thought has crossed my mind that perhaps she, being a public defender, she is just so bogged down with other cases that
no, I
she
don't
is
think that
a
came from me.
bad
I don't think that came from me.
It
attorney
did not come from the state.
for her clients.
I think it did. I can go back to
What a
he
good
emailed,
overall.
or from the parties, and was represented as, but it's not in the statute. Neither is the definition of
Professional.
insurer,
But I
and
wouldn't be
neither is the
kind of-
definition of substantial step. That's why we have highlighted.
Oh, I
those.
know where this came from. Mr. Bloodworth and I had a discussion about the fact that the way that it was originally written, she wouldn't have had to do anything. She
Hey
could have
guys,
just
please hit that thumbs up button.
imagined
you.
it and never taken an actual step towards the commission of the crime. And that language got put back in after we had that conversation. I think, and we were trying to fix that problem. And I
How
think
does she
that
still
was
have
what
so many
Mr. Bloodworth
concerns?
added to fix the problem.
No one's turned
I
off her
was the one
mic.
that originally said the way it's written, she could just think about it and be guilty. She wouldn't have to do anything.
I think an act is kind of, implicit in 3 by means of false or fraudulent pretenses, representation, promise, or material omission. I think that's the act here.
Well, I understand the point. It seems that the actus reus under 521 2D would be the devising the scheme, which I think is Ms. Nestor's point.
Right.
Well, if you devise it,
I could think of one right
never
now.
say anything or
Right.
do anything, have you violated the statute?
Right.
So what is the actus reus? What's the conduct?
By means of, and then those.
Well, but that's just a modifier on the scheme
Right.
that you've devised. I think the operative verb there is devising.
All you do is press.
I do know in federal court
screen
law, it's
twice.
clear
Do-do.
you have to take a substantial step. I don't
And
know
it
if they
likes-
just have an objection to the word substantial, but you got to do something. Something has to be done other than thinking of it in your head.
Oh, that's dangerous, Kristen.
Why don't we just instruct regarding what the state's theory of the crime is?
Right.
And either they proved it or they didn't by beyond a
Especially if you're
reasonable doubt.
That
lurking.
would be fine with me.
I mean, forgive me, count 3 is I get confused between count
It's
3
the
and 4.
scheme one with the $100,000 two-stage policy.
Yeah.
So
Thanks for
Um,
hitting the like button.
By the application.
yeah, the fraudulent, false or fraudulent pretense.
It's the submission of the application with the fraudulent stuff on it, right?
It's the submission of the application, but it could also be
This win
Just signing it.
filing the claim as well, but yeah.
is like violent.
Okay, sure. Yeah. You could, yeah.
The
You
cat
could-
loves it.
We could instruct the jury that the state's theory is that Kouri Richins committed this crime by A, B, and C. I give it,
Or-
yeah, right, yeah. We'll take a break. You can all give that some thought, maybe talk to each other.
Really?
I understand your concern,
What do you possibly need a break from?
but it seems that we don't need to be coy. We can just tell the jury
Yeah.
what the state thinks and give the state proof that they did. Okay, give that some thought. Okay. In terms of our initial review, let's keep going. Elements of count 4. Just read through that for me for a moment. Let me know if anything sticks out.
Judy. I think they stole it off the movie set for Family Matters.
And it also tracks the case.
Okay.
Thank you for commenting, Judy.
Mr. Burmester, let me know when you've reviewed it.
On 4?
Yes, sir.
No objection. Sorry.
That's okay. So then let's look at elements of forgery, count 5, 76-6-501. 2B1. An actor commits forgery if, with purpose to defraud anyone, or with the knowledge that the actor is facilitating a fraud to be perpetrated by anyone, the actor makes, completes,
No.
executes, authenticates, issues, transfers, publishes, or utters any writing so that the writing or the making, completion, execution, authentication, issuance, transference, publication, or utterance purports to be the act of another person, whether the person is existent or non-existent. This is the signing of the true stage life insurance application, signing of Eric Richins' name allegedly to the true stage life insurance application. Correct, Mr. Burmester?
Yes.
Okay.
Oh, there it is. Got it.
So we've got to keep with purpose to defraud anyone in there, right?
Yeah.
Out of paragraph
Hey
2.
guys,
Okay. But then
how's it
I
going?
think if I understand what you submitted correctly, you're asking for without the authority to do so.
Right.
Just me
That's right. And that's
acting
what's
in that
outside of
voice
the
is
case law
pretending to
on
be
that.
someone
State
else.
versus
Fraudulent.
Gonzalez, State versus Collins, and I think the state has agreed to that.
Is that correct, Mr. Burmester?
Yes, Your Honor. That's an
Okay.
element that
Very good. So
supported by those cases.
2 and 3 state,
Okay.
correct?
You got me,
Yes,
Judge.
sir.
Yes.
And then do we need
got
to,
me good.
can we skinny down 4 in any way to match the state's theory?
Can we just lock her up and call it a day? I've never ever said that
I don't
before.
know
It's
if we
just the
have
way it goes.
authentication.
Oh no,
I mean,
I'm just
execute
talking
and
like
authenticate
that.
don't really match
who
the
lives
facts
in the
of
shoe.
the case.
Isn't execute just sign?
From
Yeah, because
the
I
state
thought execute meant make it
prosecution
effective.
table.
Like, I don't know. And authenticate usually means notarize or something like that. I still don't know what utter means.
Well, we can go back to page, any intentional act that puts a writing into circulation and
I'm
implies
thinking
by
about some
word or
intentional
action that the
acts right
writing is
now.
genuine.
I mean, it just seems like you could say make or complete a writing, or just make a
Leave,
writing.
make or utter.
Yes.
Make
That's
or
what I
utter.
think.
Utter's weird word.
What are you
Thanks,
gonna
Vicky.
do to my udders?
Mr. Burmester, make or utter, or make, execute, or utter?
Either of those two alternatives are fine for the state.
All right. Court rules that paragraph 4 should read, did make, comma, execute, comma, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person, whether that person is existent or non-existent.
You can, Willa, but
Do you want to take out the
she
last clause?
continuously says, I'm not
I
very
mean, we're dealing with an existent
technology
person, so it
smart.
seems
Yeah.
Like,
kind of pointless.
Any objection, Mr. Burmester?
No, Your Honor.
Okay.
and she's wearing the Pepto-Bismol again today. I can't.
Thank you. Okay.
And I'm gonna
Paragraph
pray for
50,
myself tonight. I've been
51,
a little
52,
sassy.
53 are Muji second standard instructions.
Yeah.
I agree
Yeah.
with that it is 50. But, it certainly
Wow.
doesn't preclude one from arguing where two charges might be related
Okay.
factually.
No, certainly not. The state in its
I live in a shoe.
its closing can start with count 1 and then pivot to saying you can consider the strength of the evidence regarding count 1 as part of your consideration of count 2.
Okay, I just wanted to make sure we're
What
not.
we can't let the jury
Right,
think is that
right.
if they find a defendant guilty of aggravated murder, well, screw it. We're just going to click guilty on the rest.
I totally understand the rationale for it, but
Okay.
as I read through it,
Okay.
I think it might happen.
Okay. Page 54 is a edited version of what would normally come after as the second paragraph of page 53 to reflect that this verdict form has a lot more blanks than just 2.
Okay.
Huh?
I'll take a look. You will see, please, the verdict form is separated into, I'm just going to say several sections.
To several sections.
Yeah,
Okay.
one section for each count charged.
I kind of want to see if my weather data is accurate per the National Weather Service.
Any
Give me
objection,
one
Mr.
second.
I couldn't understand what you said.
No problem. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into, it currently says 2. I'll edit it to say several sections.
Okay, no objection.
58 miles per hour.
No objection.
Okay. 55 is a Muji standard instruction. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
56 is a Muji standard instruction. It was part of the party's proposed inclusions pre-trial I'd like to hold it in reserve so I at least have a place to start if the jury reports that they're having trouble reaching consensus.
Oh, I do not think this will be an issue,
Well,
Your Honor.
I just don't see the harm in doing, I mean, I think, I always want jurors to be instructed by the court, not just us, that they're not to surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of their fellow jurors.
I
or
agree
just
with
to
that.
return a verdict.
I
just-
agree. And that's why you should look at paragraph 3 on page 51.
Oh, okay. Did you stick it in there? I didn't see it.
No, it's just part of the standard overarching.
That's what
unanimity
she said.
instruction.
Oh, that's fine.
I recently had a hung jury. I need a place to start to apply gentle pressure to keep working. And this is something I'd like to have in reserve. Okay, so I'm not going to give this as part of the pre-closing instructions.
There is a typo on it.
I'll fix it. What is it?
Third line from the bottom, do not surrender.
Thank you. Got it.
Do
kind of an
not
important section.
surrender.
Okay. All right. May we please, and Ms. Nestor, we're going to come back to your submission here before I take a break.
Okay.
Let's go to
Great.
the verdict form next.
Okay.
Fairness, this was the last thing I did before I came on the bench, and so there may be some typos or flow errors here, but let's just go through it one at a time as if we were
Yeah,
jurors
Anna.
answering it to make sure that it flows correctly.
Hey guys, I see a lot of new people. Please hit that thumbs up button. Make sure that you are subscribed. This is when I normally am live. You are not confused. It's been a whole thing today.
Well, unless it's at the beginning.
Oh, here comes Mousy.
I don't think I got a copy of the verdict.
I think it was in the email that I sent after I sent a copy of the jury instructions.
I did not receive that email.
Hold on, Wendy, I'll send it to you right now.
That is
Just
entirely possible.
Thank you.
No, you did. Or at least I sent it.
I didn't get it, but
let me forward
Kathy,
it.
maybe you should resend it.
Yeah, I'll send it right now.
Thank you.
There's Kouri once again, looking like she's gonna puke all over
I
her
just sent it.
brand new shirt.
I should say skip to count 2.
Or and take out 1B. And so this has to change to 2.
Huh. You guys see me? Do you guys hear me? Oh my God. What did you do, Coco? What did you do? How am I seeing this if the internet's out? I'm confused. What is going on? There's no way this is working. It says I don't have internet.
Okay.
Oh. Well, I'm without electricity, which I figured was going to happen.
So let's see. Let's start with you, Ms. Nestor. So we'll take out the plural
This
of
is wild,
inquiries,
man.
and we'll say skip to count 2, there'll be no reference to 1B. We'll just omit inquiry 1B, right?
Right,
Same for count 2, similar changes.
right.
Any other changes?
Yes, so.
I'm going to
I have
switch to my
some
laptop
Worries
to save battery on my
about
phone.
it not being, I know we have an instruction on it that's separate, but I sure would like it to be clear on the form of the verdict about that it has to be unanimous as to each one.
Doesn't it say unanimously regarding each one?
It does, but
Unanimous?
you could be
Someone's
saying
never heard that word before.
unanimous